The Royal Commission into Violence, Abuse, Neglect and Exploitation of People with Disability is now in session.
Good morning to everyone who is following these proceedings. This is the sixth day of Public Hearing 20 on preventing and responding to violence, abuse, neglect and exploitation in disability services, with special emphasis on 2 case studies involving life without barriers. We commence, as always, with the acknowledgement of country. We acknowledge the Gadigal people of the Eora Nation, the traditional custodians of the land on which Commissioner McEwen and I are participating in this hearing. We also acknowledge the Wurundjeri people of the Kulin Nation, upon whose lands Commissioner Galbally is participating in this hearing. We pay our respects to their elders, past, present and emerging, and we also pay our respects to all First Nations people who may be attending the hearing, and to those who are following the hearing on the live stream. Yes, Mr. Griffin.
Chair and Commissioners, I call Claire Robbs. Ms. Robbs is the Chief Executive Officer of Life Without Barriers. She has provided 2 statements for this public hearing. A statement dated the 17th of November 2021 and a supplementary statement dated the 8th of December 2021. The first statement has an identifier STAT.0485.0001.001. This statement is in Hearing Bundle D, Volume 1 at Tab 1, and the annexes to her statement are in Hearing Bundle D, Volumes 1 to 4, Tabs 2 to 380. Ms. Robb's supplementary statement bears the identifier STAT.0485.0002.001. This statement is in the Hearing Bundle D at Tab 1, capital A. Statement is comprised of 14 paragraphs designed to correct a small number of typographical and otherwise minor errors in her first statement. Ms. Robbs also gave a statement to the Commission for Public Hearing 5 of this Royal Commission dated the 14th of February 2020 and a supplementary statement dated the 19th of August 2020. Ms. Robbs gave oral evidence to the Commission on the 20th of August 2020. Might the witness be sworn?
Yes, thank you very much. Ms. Robbs, thank you very much for coming to the Royal Commission to give evidence today. As you heard, but I shall repeat to make sure that it's clear, Commissioner Galbally is joining this hearing from Melbourne, and you can see Commissioner Galbally on the screen. Commissioner McEwen is on my right and of course participating in the Sydney hearing room, and as you can see, Mr. Griffin is also in the Sydney hearing room, and shortly I will ask him to ask you some questions. If you would be good enough in the meantime to follow the instructions of my associate, he will administer the affirmation to you. Thank you.
I will read you the affirmation. At the end, please say yes or I do. Do you solemnly and sincerely declare and affirm that the evidence which you shall give shall be the truth, the whole truth, and nothing but the truth?
Yes.
Yes, thank you, Ms. Robbs. I'll now ask Mr. Griffin to ask you some questions.
Ms. Robbs, is the contents of your statement dated the 17th of November 2021 true and correct to the best of your ability?
Yes, it is.
And likewise, with your supplementary statement dated the 8th of December 2021, you say that's true and correct to the best of your ability?
Yes.
Ms. Robbs, I understand that you wish to read a public apology in relation to this public hearing. Is that the case?
Yes, please. Thank you.
Can I invite you to do that now?
Yes, thank you. I have read the evidence given by residents and their families during this hearing to the 2 Life Without Barriers homes that are the subject of the case studies. I have also listened to the evidence of all of the witnesses, including people with a disability, their families and other experts the Disability Royal Commission has heard from during this hearing. Life Without Barriers exists to partner with people and change lives for the better. And whilst I witnessed the extraordinary work our organisation does for thousands of people every year, it deeply saddens me that for the people who have shared their stories with the Disability Royal Commission, our organisation has not met this promise. I recognise that when we partner with people who choose our services, we are supporting people who are loved members of families and valued members of our communities who have fundamental human rights. The people and families who offered their stories to the Disability Royal Commission have provided invaluable insights in areas we acknowledge we have further improvements to make. We have also listened carefully to the experts who have given evidence during this hearing, and we are committed to ensuring their evidence informs how we support and work with residents and their families in the future. The views and experiences of people and their families have highlighted several areas where harm has been caused to people, and we acknowledge and offer our deepest regret. I would like to focus on the particular residents whom the Disability Royal Commission has heard from either directly or from their loved ones. For Sophie and her family, the physical abuse Sophie experienced is unquestionably not in keeping with Sophie's right to feel safe and respected in her own home. I do not condone the violence towards Sophie, and I offer Sophie and her family our sincere apology for the harm caused to her, including for the manner in which our investigations into the matter was undertaken. I also recognise that we should have been more supportive in relation to Sophie's wish to engage in sexual relationships, including to ensure that Sophie had a safe location to do so. I thank Sophie for her unique insight to the importance of romantic and sexual relationships for people with a disability, and I commit to leading further actions we will take as an organisation that are informed by the people we support. For Natalie and her family, the sexual misconduct by a staff member is completely unacceptable, and I acknowledge the pain and trauma that has caused Natalie and her family. Our priority should have been to protect Natalie earlier. I offer this apology to both Natalie and her family with a full understanding that our delay in offering a genuine and human response was also unacceptable. I recognise the pain and fear that Natalie must have experienced during the acute episode in relation to our bowel care about which the Commission has heard. I also acknowledge the frustration on Jennifer's part, particularly the gaps in documentation in relation to Natalie's bowel care. We also could have been more communicative and reassure Jennifer about the proper spending of Natalie's money. I would now like to apologise to the residents of the Melbourne House and their families. For Rebecca and her family, I apologise that Rebecca felt she needed to have a goal of feeling safe in her own home. No home should feel violent and unpredictable, and I appreciate the conflict between residents can cause considerable distress both to those directly impacted and people living in the home. I acknowledge that Robert's family raised a number of concerns and requests, and I am reminded of the importance of the family's rights and their important role to advocate with our organisation to ensure we are recognising the individual preferences and choices of people with a disability. I offer our apology for the delays in addressing the concerns and requests raised by both Rebecca's and Robert's families with us. I also apologise to residents and their families of the Melbourne House for the other instances where we could have done more to respond to and reduce where violence was occurring between people in the home. Finally, to each person whose story has been told through this hearing, your words and experiences have been a powerful reminder of why we must continue to strive to be the very best organisation we can be for the people we serve. Thank you.
Thank you, Ms. Rhodes. Before I ask any questions, can I ask whether you've been watching the hearing to date or read transcript in relation to the evidence in this hearing?
I've watched all of the witnesses to date.
Thank you. Can I begin by asking you a little bit about the history of Life Without Barriers? And I take this from one of your annual reports. The organisation was established in 1995 in Newcastle.
Correct.
And in 1999, Mr. Ray Dunn became the CEO. And at that time, more staff were recruited, the business was expanded, and some New South Wales government funding was applied for.
Correct.
Between 2001 and 2002, LWB expanded into Queensland and South Australia.
Yes.
And then in 2005, you expanded further in South Australia and also moved into the Northern Territory.
Yes.
In 2006, you established operations in Tasmania and in the far west of New South Wales.
Yes.
In 2007, you commenced operations in Western Australia.
Yes.
Finally, in 2009, you expanded into Victoria and New Zealand. In 2011, Mr. Dunn retired after 12 years as CEO, and you were appointed to the position which you currently still hold.
Correct.
You, in fact, have been working for Life Without Barriers since 2004.
I have.
Why was Victoria the last state in which LWB commenced operations?
We always had an approach where we only provided services in jurisdictions or states that requested for us to come to do that, or where there was a particular gap in the service system that we thought we had something unique to offer. Victoria has had a long-standing, very strong service sector in the disability sector, and really up until we made the decision that we would offer services, there wasn't a particular gap that we felt Life Without Barriers had something unique to offer.
Was the fact that Victoria had a slightly different regulatory model a factor in your late incursion into that state?
No, not at all.
When you became CEO in 2011, there was a board of directors comprising 9 members,
Yes.
and 8 of those 9 members had been on the board of LWB for at least 5 years at that time. Does that accord with your recollection?
Yes.
And the board included Mr. Terry Lawler, who had been one of the original founders of LWB.
Correct.
You would concede that in those circumstances, it was an experienced board in the sense it was experienced in the operations of LWB.
Yes.
When you commenced as CEO, did you attend all board meetings?
Yes.
Were you ultimately responsible for what was included in the agenda for the board meeting?
Not solely, no.
What other people were involved in setting the agenda for the board?
The agenda for the board meetings is generally set with the chair and the chief executive, and sometimes other directors if there's items of particular note or items that would be carried forward from a previous meeting.
And as CEO, did you have the authority to escalate an issue to the board at any stage?
At the board meeting, sorry? Or
No, just generally.
Oh, just generally. I would think that would be the responsibility to do that, yes.
And so if something arose between scheduled board meetings, you nonetheless could still make board members aware of it?
Yes.
Mr. Griffin, you're intending these questions to relate to the whole of the period, 2011 to 2021?
2011, I'm going to move on to later on.
Yeah, no, I just thought that
sorry.
Ms. Robbs may have misinterpreted
Okay.
your question.
Sorry, thank you, Chair. I did. Sorry, my apologies.
So was it the case from 2011 till the present, you've always had the authority to escalate an issue for consideration by the board?
Yes.
And I take it that initially Mr. Terry Lawler, the chair, was readily available to discuss issues with you.
Yes.
In 2015, the constitution of the LWB board was amended to impose a time limit of 9 years on board membership. Is that correct?
Yes.
What was the thinking behind that decision?
My memory was that it came out of some good practice guidelines, most probably from the AICD at the time, suggesting that there was, tenure incorporated into constitutions and boards.
And AIDC is the Australian Institute of Company Directors.
My apologies, yes.
And so you understood that it was regarded by 2015 as good governance to use my words, refresh the board.
Yes.
That amendment imposing the 9-year term limit didn't apply to existing board members in 2015, they did it.
I think what you're asking me is, did we start, did the start date, was the start date when the decision was made?
Now, what I'm asking you is when you amended the Constitution, that was to apply to all people appointed to the board from that date onwards. It didn't apply to existing board members.
Sorry, I think it did apply to existing board members.
Well, in 2015, as I understand it,
Yeah.
you had a director in Terry Lawler that had been on the board since 2002. You had a director, Tracy McCosker, who'd been on the board since 2002. And you had a third member, Jan Lowe, who'd been on the board since 2004. All of those would have been ineligible to continue on the board if the amendment applied to them. Do you agree?
So I think that's why I was just seeking that clarification, because when the amendment came in, my understanding was that the board said it was started as of the date that the decision was made.
So by that, do you mean, did the 9 years start to count from 2015 as opposed to only applying to new board members?
Correct.
So we weren't dealing with a situation where existing board members were grandfathered
No.
in that sense. Thank you.
No.
Now, Mr. Lawler has now retired in 2021, I believe.
Yes.
Along with Mr. Anthony Deegan, who'd been a director for 9 years, and Mr. Dean, who'd been a director for 6.
Correct.
And your current board, as of 2021, is got a relatively new group of members of different levels of experience as board members.
No, I think there's a good mixture of people that have been on there for some time. There are some new members, yes.
Well, it's certainly the case with Ms. McCosker, Ms. Lowe, and Gillian Calvert, who have been on the board since 2002, 2004 and 2012. Mr. Graham Innes has been on the board since 2014, correct?
Sorry, that doesn't sound correct to me. I'm sorry, yeah.
I'm subject to correction, but I took that from your annual reports, but I may have made an error. And then the remaining board members, Natalie Walker, Helen Soke, is it?
Yes.
Kirk Fernley, Rajiv Viswathan, and Paula Head, the company secretary, have all been appointed from 2017 onwards. Does that accord with your recollection?
Sorry, I think you are correct around Mr. Innes. My apologies.
Right.
That is correct on the other directors. Ms. Head is not a director. She is a company secretary and an employee.
Yes,
Yeah.
that's correct. During your time as CEO, that's over the 10-year period, have you raised directly with the board any issues specifically relating to the Lismore houses?
My understanding is that the matter related to I think it's worker 3, sorry, was reported through to the board for the risk committee.
Right. So you've certainly raised an issue in relation to an employee. Have you raised any issues over that 10-year period with the board in relation to any resident of the Lismore houses?
I don't think so. Sorry, thank you. That's very helpful. Thank you.
So can I assume, Ms. Robbs, that the situation involving Sophie and the sexual assault perpetrated against Sophie, to your recollection, was not escalated to the board of directors?
Yes, that's my recollection.
Given the fact that Sophie was assaulted and the perpetrator was charged with a criminal offence and taken to court and convicted, can you indicate why you took the view, assuming you knew that at the time, perhaps I'll go back a step. Did you know that was happening with Sophie, that she'd been assaulted, someone had been charged, and he'd been taken to court?
I think I knew, but I cannot find the documents that say that. But yes, I do think I knew.
Going back to my original question then, did you then raise that, I'll call it incident, with the board?
No, I did not.
Can you explain to the commissioners why you didn't?
Yes. So the reporting to the board of directors around incidents is generally around where the responsibility for the incident occurs within Life Without Barriers. So where we would be responsible effectively for the incident. In the Sophie matter, that didn't occur, the sexual assault didn't occur while she was in our care effectively. And as a result, at the time, it was noted as an incident in her personal records, but was not flagged through the incident system.
With the benefit of hindsight, if those events were to occur in 2021, would you take a different course in relation to the board?
So if though the same sort of event was to unfortunately happen today, then the event would expect it to be entered onto the incident system, and then it would be assessed by the National Safeguarding Unit, and it would be managed differently.
But specifically, would you as the CEO raise directly with the board an incident such as I've described with Sophie?
I'm just hesitating about where it would go in regards to the purpose of the reports. The reports to the board, the general purpose of them is to report around, our responsibility. I appreciate the magnitude of something like this in someone's life, not questioning that at all. I'm just hesitating what the purpose would be and where that would go in the board reporting at the moment, the way we do it at the moment.
Can I take you back a step? I understand the distinction you drew between what happens within LWB and what happens externally. But you know from the evidence in this public hearing that there were certain rules in relation to Sophie in the Lismore house that gave her no ability to have someone come into the home after 6 p.m. Correct?
Correct.
You know from the evidence that when the man turned up to collect Sophie, it was about 9 o'clock at night.
Yes.
You know that staff apparently expressed surprise in the sense that he was surprised he was picking someone up from a disability home.
Yes.
In those circumstances, why do you maintain the distinction between events internal to LWB and events external? Aren't you, in effect, at least morally responsible to treat that as if it happened in the home in terms of your reporting?
I think the reporting, appreciate the point. The reporting to the board is about our responsibility around our care to individuals and whether we are responsible for harm under our care. That is different to a sense of general moral responsibility. I think it's about the purpose of the board reporting. So no, I don't think that in that sense, it would be reported directly to the board with the incidents that we hold responsibility for as Life Without Barriers.
I should be frank with you, Ms. Robbs. I'm troubled by your answer. What I'm suggesting to you is the imposition of those rules, in effect, made LWB in part responsible for what subsequently happened, because Sophie was denied the opportunity to have someone in her home and consequently was put in a more vulnerable position. Do you accept that proposition?
No.
When you outline the reporting to the board, up until this day, have you spoken to any board members currently on the board about the events surrounding Sophie?
Before the
Up until today,
up until
have you
today.
had any discussions with any current board member about the events that Sophie told this commission about?
During the preparation and the commission?
Right up until today.
Up to date, sorry, my apologies. Yes.
Have any of those board members expressed a view that they would have liked to have known about it if it arose on their watch?
I think what the conversations with the directors that I've had through the preparation and hearing the witness statements, particularly from Sophie and her parents and others, have made us reflect on a number of things in the organisation. One being around the suitability of the reporting, the robustness of the systems, which I think is all exactly the type of conversation you would want a chief executive and board to be having around matters like this, when it's brought to our attention through processes like this.
Do you recall listening to the evidence of the experts, Jodie Rogers and Ms. Dorr?
I do, yes.
Do you recall the tenor of part of their evidence was that by compelling a resident in a group home to meet people outside the home, it had the effect of potentially increasing their risk? That is, contrasting meeting within the home and meeting outside, potentially put the residents at greater risk. Do you recall that evidence?
I do recall that evidence. My response to that in listening to that evidence is that I appreciate the general comments made by the two experts, and they made some valuable comments. I don't think they would have appreciated the full complexity of the situation at the time, and I think that's where the more difficult work lies, in that individual complexity, not in a general sense of what ought to possibly happen in an instance.
Ms. Roberts, have you had the opportunity to read the statements of Ms. Dorr and Ms. Rogers?
To
read their
read
statements?
them, I listened to them.
And you'll know, won't you, that in a request for them to provide statements, the Commission set out a scenario in 5 stages. You're nodding, you're saying yes?
Sorry, I'm not aware of that, sorry. Yeah.
Right. Well, in the evidence, I took them through 5 particular issues, and those scenarios were based broadly on Sophie's story. I'm puzzled by your answer that the experts wouldn't understand the complexity of what was going on at the time. And I was wondering whether you might elaborate upon that complexity for the commissioners.
So I appreciate that they had some information. I think when I read the material and of around the events at the time, and I look at the documentation, much that you've has been in the hearing, and particularly listen to Sophie and her parents, I can see that Sophie and her parents and our staff were grappling with how to balance Sophie's dignity of risk to relationships and sexuality and choices and control, and the sense of duty of care to Sophie and to the other residents in the house. And I can see that through the documentation. I think that it's that that's the complexity, I think, that I'm talking about, to that level of detail and that level of very intimate understanding of Sophie and her family and the other residents in the house, and how that, you know, played out on a day-to-day basis as well. And it's that piece that I think makes things more complicated.
I think Mr. Dolly has a good understanding of these issues.
Yes,
You've heard Mr. Dolly's evidence yesterday.
I did, yes.
You heard Mr. Dolly concede that the rules that were formulated and applied to Sophie were inappropriate.
Yes, I did.
Do you accept that?
I'm not sure inappropriate's the right characterization.
What is?
I think they were really well-intended. I think they were trying really hard to balance up needs, wants, you know, pressures, and I think they did their best job on the day. I understand.
People can do the best job they can and still produce an outcome that is unsatisfactory. That's the case, isn't it?
Yes. Yes,
So
that is the case. Yeah.
I'd like you to consider, do you accept the concession that was made by Mr. Dolly that these rules were not appropriate for Sophie at that time?
I would have liked us to be able to do something better
Could you answer my question?
to solve that problem.
Could you answer my question?
So could you perhaps just repeat the actual question to me?
The question is, do you agree with the concession made by Mr. Dolly that the rules that were formulated at the time for Sophie and where she could experience intimate relationships were not appropriate?
I'm sorry, I can't agree with the appropriate. Sorry.
What can you agree with? What are you saying, they were appropriate, as distinct from the people who formulated the rules trying to do their best? Let's assume that's the case. It doesn't answer the question as to whether the rules that were actually enforced were appropriate for Sophie's welfare.
Yes, I understand that good people can do things with good intent and still get an outcome that's not satisfactory. I understand that. I don't feel appropriate is the right characterization in this instance. I think don't think they're inappropriate in that way. I think I would have liked us to have been able to come up with a different way to manage the risk and Sophie's goals.
Can I come back to your answer to Mr. Griffin earlier? I'd like to be clear as to when, on your best recollection, you became aware that Sophie had been assaulted outside the premises run by Life Without Barriers. Was it shortly after the event?
I can't recall that. My apologies. I'm sorry.
In any event, when you first heard about it, were you aware of the circumstances, including the existence of the plan, the fact that Sophie had gone out at 9 o'clock at night? Were you aware of any of those things?
I became aware of the detail of the safety plan during this hearing. I'm sorry, my apologies. In preparation.
In preparation.
Sorry.
So prior to this hearing, your knowledge of the assault that was perpetrated on Sophie was limited to the fact that Sophie had experienced this assault outside the premises conducted by Life Without Barriers. Is that right?
Yes.
How could you possibly know, if that was all you knew, that this was not Life Without Barriers' responsibility? How could you know that without making detailed inquiries as to the circumstances that led Sophie to be outside her home at night and in circumstances that led to a sexual assault? How could you make the judgment that this was not Life Without Barriers' responsibility? You couldn't know, could you?
Well, I think that the matter was investigated.
No, I'm talking about your knowledge.
Yeah.
Prior to this hearing, you have said the only knowledge you had was that Sophie was sexually assaulted outside the home run by Life Without Barriers. And you have also said that the reason for not notifying the board was that this was not a responsibility of Life Without Barriers, the event having taken place outside the physical premises of Life Without Barriers. That's what I understand you to have said. And I want to know how you could make the judgment that Life Without Barriers was not responsible without knowing the details of what happened and how it came that Sophie was in this position.
My apologies. I understood you were asking if I had seen the safety rules before the preparation. My apologies.
All right. Well, do you understand the question?
I do understand it. Sorry. I had not seen the particular safety plan before the prep of the hearing, but I know that there had been processes undertaken within Life Without Barriers, some of which is in the documentation, which showed that we had reviewed the events around the sexual assault. And
are you saying that you only learned about the sexual assault after investigations at the same time as you learned that investigations had taken place?
Sorry, I'm not as
no
in the flow, not particularly. Yeah,
no. Well, I share Mr. Griffin's concerns about your answers because they do suggest that you made an assumption that as long as this event occurred off premises, Life Without Barriers could not be responsible. Is that a fair assessment?
I don't agree with that.
Why not?
Because I know that we have really very strong processes and checks and balance in place to make sure that we review matters. So we generally are an organisation that looks for our responsibility in matters.
Yeah.
and takes that responsibility and on. We certainly don't shy away from that any way whatsoever in the way that we review, particularly matters of this concern.
All right, thank you. I'm sorry to have taken so long, Mr. Griffin.
Ms. Robbs, are you saying that the board is only interested in matters of legal responsibility, strictly defined?
No, not at all. I'm saying that the reporting to the board for particular events or incidents generally is around where we have deemed we have some direct responsibility for the matter.
And that responsibility is using the word in a very general sense that includes legal and non-legal moral responsibility, does it?
I think there are protocols and processes in place which say what's reported to the levels in the organisation. Whether they particularly refer to those points, I couldn't say, sorry, but there are guidelines around what's reported to the board and to myself and why.
I understand that, but isn't the core of LWB's operations the care of the residents living in their various facilities?
Absolutely, absolutely.
That's your central reason for being, isn't it? To take care of those people.
Our central reason for being would be to care for.
And so if a resident, for whatever reason, suffers the tragedy which befell Sophie, isn't that at the centre of your care for her, that you'll take a proactive approach to trying to work out why it happened and to what extent Life Without Barriers may have contributed to those events?
There is absolutely no doubt that the care for the people, the quality of the care for the people that we support is our absolute driving force for the whole, all of the work we do. And yes, in instances where events happen, like the event for Sophie, which, sort of impactful and life-changing, then absolutely it's beholden upon us as an organisation to understand that fully as we can, and then consider what we need to do to repair what we can for that individual, but also any broader learnings. And we work really hard to do that.
But your reporting requirements internally did not automatically escalate Sophie's position to board level. Now, those reporting requirements are ones that you've decided on as an organisation. They're not imposed from without, are they? You decide what you report to the board. Can I come back to the question? In those circumstances, why wouldn't you report the details of what happened to Sophie to the board?
So, going on your last question there, I think that as I said a moment ago, the care being the ultimate priority and our ability to understand events that have impacted people, to repair anything we have from that, and to learn from that is something we're ever vigilant to, in Life Without Barriers. I think the assumption that is our care is categorized in one document, be that a board report is not a reasonable assumption.
Ms. Robbs, before the chair asked you questions, you had explained to us that Sophie's situation was very complex.
Yes.
If one assumes that all questions of dignity of risk, the right to have intimate relationships, all have their complexities in each individual case, how can a board decide on what an appropriate policy is for the organisation if they're not aware of those complexities? And as a subsidiary to that question, wouldn't the best way to inform and educate the board to say to them, before we consider our policy on these issues, let me tell you the story of what happened to one of our residents?
So if I can just take that question into two parts, possibly. The second part that you are talking about around how do we have conversations with the board, particularly perhaps board members that aren't as familiar with our work at a frontline level, so that when they're making decisions around policy or other governance related decisions, they understand how that may impact on the individuals that we're responsible for. I think that's a very important role for us to do. And we do a lot of activities with the board so that they have direct contact with people, so they do hear stories, so they do actually get an opportunity to understand the lives of the people that we support at a level of detail that enables them, hopefully, to make good informed decisions in their governance role. So that's more of an education role with the board, and I feel we're very strong on that. I think that is different to a reporting and governance and assurance role, so I'll just split the two.
Mm-hmm.
And perhaps, my apologies, Councillor, you could just refresh my memory on your first question. My apologies.
I was talking about whether the particular complexity of Sophie's situation wouldn't have been highly informative to the board in terms of determining what policy they might seek to adopt.
Yes, thank you. Thank you. So I think what I've just answered explains the piece about here's an example or a case study or a story. So I feel that's I've answered that. To your first question, I do think that if I reflect on Mr. Jolly's statements yesterday, I think he articulated the point you're making around the policy, which we have lots of good policies, is really important, very important, as well as actually what's happening for the individual and their individual circumstances. And they are connected, but quite different in regards to a policy that's relevant for a whole organisation and lots of people with completely different needs in comparison to each individual's particular circumstances and needs. So in that way, it is important that the board understand stories and case studies and meet people and understand the places we provide the services and meet the people. That's really an important part of them understanding how to make policy decisions.
Now, no one would dispute that having policies is important and indeed laudable. But the other aspect of any policy is it understood by the frontline staff?
Mm-hmm.
And do they have sufficient training to deal with situations which are relevant to the policy? How can a board determine a policy without thinking about those factors?
That is a good question, and one that we have been working with the board on around when they agree a policy, when they approve a policy, they want us to bring, and we've only just started doing this, bring the implementation plan for that policy or new system or improvement, particularly to your point where they could approve the policy, but if they don't really have line of sight that we have a really solid plan to implement, then it's, just a policy.
The board has a policy before them which it's considering.
Mhm.
Isn't an important part of that consideration to say to the board, here's a case study of what happened in one of our homes. If we apply this proposed policy to that case study, would the outcome have been any different? That's part of the consideration, isn't it?
I mean, yes, we do use case studies. We would often use case studies perhaps on more complex matters where it might be difficult for directors to pick up that information when they're out on their visits and when they're talking with people, because it's more personal and complicated. So we certainly would use case studies in lots of different ways to try to help everyone in the organisation, including in staff training and in decisions at different levels, so that we're always really focusing on what is the impact of the decision that we're making today on the lives of the people that we are responsible for. I might just grab some.
You've got a Executive Masters of Business Administration from the University of Sydney.
I do.
You obtained that qualification in 2012.
Yes.
LWV is a very large organisation.
Yes.
Has a revenue north of $750 million per year currently.
Correct.
You've described some of the reporting lines to the board. As Chief Executive Officer, who reports to you directly and who is part of your executive team?
You mean now?
Now, sorry, yes.
Now, as we sit now. At the moment, I have an executive team that has an executive responsible for our disability services and mental health services, an executive responsible for our child, youth and family services, an executive responsible for our people safety and culture, an executive responsible for our risk and assurance and quality, an executive responsible for our strategy and engagement, our marketing, an executive responsible for our finances and our commercial services, and an executive responsible for our ICT.
And information in relation to those various areas of the organisation are fed up to you as the CEO.
Yes.
During your MBA, were you taught that many successful CEOs in all sorts of organisations allocate a significant time out of their working week to walking the floor, that is, to going to their workplaces and talking direct to frontline staff? Is that a concept that was discussed during your MBA?
I'm sure it was.
Do you have a process in place that enables you to avoid the line of people reporting to you and from time to time go direct to the frontline staff to get their take on the issues in their workplaces, unfiltered by middle and upper management?
Yes, I think that's important for all leaders to have that.
Do you do it?
Do
Do
I?
you go to various facilities run by LWB and just talk to the staff?
It's one of the better parts of my job.
How often would you do that? What percentage of your time as CEO would be spent in that type of engagement?
We don't have a fixed sort of percentage. I would. I think perhaps if I just visiting, because walking the floor is quite different in offices or buildings that often the people that talk in the MBA are talking about walking through corporate offices. So I think in organisations that do what we do out in the community, the way that I find it most helpful to really understand what's happening on the ground, what's landing for people, what's not. Are the improvements we're planning the right ones to help people on the ground? Is visiting the locations where the care and support actually happens. So be that in this environment, the homes, or in day centres or other locations where this service is delivered from, and talking with the individuals and the direct staff and their families. Sometimes it can be helpful often though to have separate conversations where we have advisory groups or family groups, and we have a National Disability Advisory Council that's really helpful as well, that doesn't have line management at the meetings, so that's really helpful for me. The other way that I gauge that is to talk one-on-one. We have a sort of a process where there's a schedule where everyone talks sort of two down in the organisation with leaders. So for me to really sense check how I think services are going on the ground, I like to visit, not in the last period of time, obviously during COVID that's been awfully difficult, but have interestingly been able to do more of that remotely just because of the travel in this country so large. Visit the houses, talk with people, staff, families, the consultation meetings, and often the line management as well is really important. But we get information from other places too, unions, regulators. There's lots of different places that intentionally go so that I can do my best to satisfy myself about what's happening out there.
Did you ever visit the Canelabar House?
No, I don't think I did.
Did you ever visit the Lismore House?
I don't think so.
Did you ever visit the Melbourne House?
I visited other houses in Melbourne, but not the particular house.
So
yes.
you haven't physically been to any of the houses that were subject to this public hearing?
I would remember if I met the residents.
Ms. Robson, you heard the evidence of Mr. Dolly yesterday.
Yes.
And you might recall that there were some questions which were, to put it mildly, handed over for you to answer because Mr. Dolly wasn't able. I just want to break and deal with those now if I can, while the evidence from yesterday is fresh in the mind of the commissioners. Do Life Without Barriers agency staff have access to the policy centre of the organisation?
They don't, no.
And why is that?
I can't see a particular barrier to that, actually. I think it's really just about the security around the log-ons to the system, the computer system. So I appreciate we've got lots of really sensitive information on the system, and so we work really hard to secure it. regardless, the way that we work around that then is that we, when agency staff are coming, and I can see actually very good examples, particularly in the Melbourne house, of this occurring, where the line management, either of the house or the next level up, are responsible for sharing the relevant information, relevant only information with an agency staff member coming on shift. There's lots of policies on the policy centre. It's probably arguable if that's actually more helpful for an agency staff member than trying to navigate through the policy centre.
Well, is there any reason in principle why agency staff shouldn't have access to the policy centre in 2021?
I think, as I said, I actually think it might not be, it may be more helpful to them the way it's happening just now, which is it's the relevant policies to do with direct care in the home that they're providing are provided, and the team leaders responsible for helping them understand the really important things about the house and particularly the residents. I think that's probably more helpful than being given access to the policy centre.
But what's the problem with giving them access to the policy centre? Is it difficult to navigate, or do you think they wouldn't understand what was there?
No, I think it's probably just about giving log-on and managing the log-ons to the system. I don't understand if there's another
so there's no
technical impediment.
There's no reason why you wouldn't give each agency staff member the option. They can go to the policy centre or not as they choose.
Don't know. Well, they would need a log on to the system to do that. I don't know, sorry.
Okay. Is that something that you intend to follow up as a result of the evidence in this inquiry?
I think we are always trying to look at how to get helpful information into the hands of people during
so
care.
Is the answer to my question yes? You are prepared to look into it?
Yes.
Thank you.
Ms. Robbs, could I just ask, you said earlier that the central premise of Life Without Barriers is the care of the individual. So if you have an agency staff come into a house and perhaps not have access to policy, what could people speculate about whether that agency staff would have the same philosophy and care and aim and objective? Do you think that's a fair proposition, that they may not have that?
Yeah, I understand, Commissioner, the proposition. I think that the material that we give the agency staff members is the most important to do exactly that, which is to help them to do their task on that shift the way we want it to be done. And that's why it's a more personal approach. I think if we, and we may give consideration to giving access to the policy centre, I think it'd be very difficult for them coming on shift, starting straight away, trying to access where the core documents were for them. Much better to have that explained to someone, by someone, my apologies, to them. Yeah, good question, I understand.
Okay, my final part of that question is, you therefore put your trust in the agency that they will provide staff who then can do that, what you've just described, to provide that support to...
Well, the staff providing the support to the agency staff are our staff. They're Life Without Barriers staff. So, so an agency staff, so if an agency staff comes on shift, it should be a Life Without Barriers staff member that explains that to them. We have through, as an example, through COVID, we did make it mandatory that any agency staff members who were coming to work in Life Without Barriers houses had to complete our online COVID training. So they did that within their agency, and we did hold the agency responsible for making sure that happened. But generally, we want a Life Without Barriers staff member to help that person understand what needs to be done on shift.
Yeah, thank you.
Thank you.
Ms. Robbs, my understanding of Mr. Dolly's evidence yesterday is that he thought that advocates and family members of residents should have access to your policy centre. Do you agree with him?
Yes, I actually I can share that when Mr. Dolly was giving that evidence, we could just put the policies on the website. You know, there's no reason why people can't. Now, there could be some technical barriers with that, I'm not sure. But the policies, yeah, I can't see why they wouldn't be shared.
You're proud of your policies and you stand behind them.
Yes, well, particularly the ones probably that are in easy English are probably particularly helpful for people. Some of the policies, you know, would be very detailed.
But even a detailed policy can have a simple English summary.
Oh,
can't it?
no, the plain English version's very, very, very good.
Thank you. Now, before we break for the morning tea adjournment, I just want to run through very quickly some other questions put to Mr. Dolly. And I was wondering if you could try and confine your answers to be as brief as possible, including that you may not know the answer. Was funding provided to the Gunnellabar House reduced as a result of the change in classification from Emergency Response Transition Unit, so-called ERTU, to a disability support accommodation?
I will need to take that notice.
Thank you. A subsidiary question to that is whether the residents and the families were told of that change in classification. You also take that on notice?
Please.
Did the Regional Operations Manager Far North Coast, the person known as LWB Manager 2 in these proceedings, have any experience in managing disability group homes when the Gunnellabar House was first established?
Sorry, I'll need to take that on notice.
Thank you. Were any additional support workers brought on to work in the Gunnellabar House when the resident Tyler moved in?
So I can't give a brief response on this one.
Thank you.
So I can't answer particularly if any particular workers came on shift, but I can say that at that time that was funded under the state in New South Wales state funding. And when they would have placed someone else in the home, it would have been general practice for them to then adjust the funding to accommodate for an additional person. That some of the funding would have remained the same because some of the costs don't vary, you know, in a house, but some do. Generally, it would have been practice under that funding for that to be adjusted.
Thank you. The Chair, I'm now about to move on to issues arising from the Melbourne House. It might be an appropriate time to break.
Yes. Perhaps I could ask the commissioners if they have any questions. Commissioner Galbally, do you have any questions about the evidence thus far this morning?
No questions, thank you.
Commissioner McKeown?
No, thank you.
I just have one question at the moment. In the apology you read this morning, you say the following: I also recognise that we should have been more supportive in relation to Sophie's wish to engage in sexual relationships, including to ensure that Sophie had a safe location to do so. Can you explain how that part of your apology is consistent with your evidence, as I understand it, that Life Without Barriers had no responsibility for what happened to Sophie? You want to think about that over the break?
No. I don't think my evidence was that we had no responsibility for Sophie in any way. I think my recollection was that the questions were more granular than that. I think we always have a responsibility for doing our best to make sure people are safe, and that's what I'm trying to apologize for and acknowledge. Sorry, in my apology.
Thank you. It's now nearly 11:15. Shall we break to 11:30? Thank you. Yes, thank you.
Thank you, Chair.
The Royal Commission is adjourned. The Royal Commission is resumed.
Yes, Mr. Griffin.
Ms. Robbs, can I go now to the Melbourne House? That was a house built by the department in Victoria for high disability support residents.
Yes.
And do I take it that LWV tended to operate that house?
Yes.
And we had evidence, I think, that at the same time you obtained the rights to run that house, you also took on some other houses in Victoria.
Correct.
How many houses similar to the Melbourne House, that is high disability support residents, did LWB operate nationwide at the time you took on the Melbourne House?
Sorry, can you just remind me of the date?
Yes, in 2011, you successfully obtained what I'll call the rights to operate the Melbourne House. My broad question is, how much experience had you had elsewhere outside Victoria operating houses which were designed for high disability support residents?
I don't have the precise number for 2011, sorry, across the country, but I do know that by 2011, we already were providing similar care in New South Wales in particular.
In recruiting staff for the Melbourne House and any other houses you took on in Victoria at that time,
Yes.
did you take anyone from the New South Wales houses who had experience in the area and to manage in Victoria?
In 2011?
Yes.
I couldn't comment, sorry.
Between 2011 and I think 2021, your revenue from disability services seems to have increased from about a third of your revenue in 2011 to now approaching 2/3. Is that correct?
That sounds, about right.
And has that been a deliberate focus of the board over those years to increase your presence in the disability services area?
Certainly what has been a focus is that as part of the NDIS coming in 2016 and onwards in various states, we really wanted to make sure that people with most complex needs who up until that point had often been in state government care, not always, but often, we really wanted to make sure that they didn't miss out on what the NDIS ought to be able to offer them in regards to choice and control. And so we did intentionally tender so that we thought we could bring our expertise on supporting people and make sure that they then got full benefits really of what the NDIS brought.
I mean, moving into Victoria, you recognise that the Victorians were taking houses which used to be controlled by the department and offering them to private providers. Is that correct?
When you say moving into Victoria, sorry, are we in 2011?
Yes, in 2011, when you decided to expand your operations, is it generally the case the Victorian government was moving from operating houses via the department into a situation where certain houses were being offered to private providers?
And possibly in 2011, certainly with when the NDIS came in, that was a very intentional thing from some states. But yes, before then, yeah.
In respect to the original residents of the Melbourne house, Robert, Rebecca, Amanda, Marco and Stevie, was LWB aware of the individual support needs of each of those residents?
On tendering, or
As soon as you got the house and you realised who the individuals residing in the house would be, were you fully aware of their individual support needs?
As part of the tendering, we would have received some information on
Right.
people. And then when we obviously started providing the services, then yes, we would have gotten to know people really well quickly.
And initially, I understand that the department would select the residents,
Yes.
and over a period of time, that process changed.
Yes.
When do you recall it changing to a situation where LWB would have a role in the selection of residents?
I don't recall a particular date for this particular house, but generally over time, particularly as the roles changed a little when the NDIS came in and the department then took on the role of the SDA provider, then that role, changed somewhat, where vacancies in houses are generally then discussed between hopefully the residents and families and the SDA provider and the SIL provider.
I'll come to that in a moment. When you first started operating the Melbourne house, was there an operations manual which told the management and the staff how that house was going to be conducted?
Life Without Barriers?
Yes.
I would have expected there were guidelines, yes.
Did you ever see such a manual yourself?
In 2011, probably.
And do you know what, broadly speaking, the contents of that manual was? For example,
Sorry.
did it mirror some manual that you had in New South Wales?
Sorry. Well, at the time, there were still the disability service standards in place, even though there were and continue to be some nuances across states. At its core, a lot of the service expectations are similar, and so yes, we would have used experience from other jurisdictions always to develop the policies and procedures.
And you're aware at that time that residents were entitled to receive a residential statement,
Yes.
and that statement would usually include information to the residents and their families about what services would be provided.
Yes.
And as far as you know, such statements were made available to the residents of the Melbourne house?
Yes, and reviewing the documentation for this hearing and on hearing the Paul speak, I can see that I heard his comments around some of that information and how helpful it may or may not have been for him to understand what was being provided.
Yes, because at paragraph 37 of your statement, you referred to a communications protocol. Do you have your statement in front of you?
Yeah.
And by all means, consult it if you need to.
So did you say 37?
37.
Thank you.
And do you recall Paul giving evidence that he was frustrated by the communications protocol and proposed to Life Without Barriers some different procedures.
Yes, I do.
And he says that he never heard back from LWB in response to his suggestions.
Mm.
Why didn't he receive a response?
I can't think of a good reason why he wouldn't have received a response. He certainly ought to have received a response.
And he ought to have received a response partly because family members can be a very important source of information for LWB, can't they?
Hugely.
And in the case of Paul, he was very thoughtful and very articulate in the matters he raised with the organisation.
Most definitely.
And he also raised queries with LWB on behalf of other residents and their families.
I understand that, yes.
And you know, don't you, from reading the documentation provided by Paul, that it's not unfair to say he was potentially a very useful asset for LWB in assisting you in how the house was run.
Yeah, I think Paul was able to really clearly share his expectations and views and experiences, and particularly obviously for his son, but other residents too.
Now, the Melbourne house was taken on by LWB under a 5-year lease.
Yes.
It had a nominal rent of $12 per annum, which amongst lawyers is called a peppercorn rent. That's correct, isn't it?
That would be a low rent, yes.
When you were providing information to residents, did you indicate to the residents that part of the service being provided included a rental component which LWB had to pay?
Yes, I would have thought that we covered that in the agreement.
And did you explicitly tell the residents that LWB was paying $1 a month by way of rent?
I'm sorry, I need to go back to the agreement for that particular time. I'm sorry.
Well, you might take that question on notice. But as a general observation, when you're informing the residents about where their money is being spent, rent really wasn't a factor, was it?
Sorry, without going to the actual document, I'm unclear if we were clear with the families that the rent collected was then paid to active housing for the repairs. Sorry, I'm not sure if we were very clear with them about that.
Let me talk about active housing. They were another body outside of LWB.
Yes.
And they were engaged by LWB in relation to the Melbourne House to provide some services.
Yes.
What were the services provided by Active?
So there is in the material quite a detailed outline and agreement with them. In essence, it was around repairs and maintenance and other issues that would relate generally to the tenancy.
So repairs to the physical structure of the home and anything in it, and maintenance in relation to the home and the grounds.
Yes. My experience of these agreements is that there's some, and I can see it in the agreements that are present between ourselves and Active, is that there are some points in that which are very clear, and there are some points in those agreements where it is often less clear. I don't think that's unique to disability houses, however. I think that's probably similar in lots of property environments. But it is sort of spelled out the functions that Active were expected to do under the agreement.
And the residents of the Melbourne House would contribute a specified sum of money from their disability support pensions.
Correct.
I think in relation to Robert, Paul gave evidence that he was charged in 2012 $536.49 per fortnight as a residential charge, of which the rent was a component, and there was also a component for utilities such as food, etc. Is that broadly the position?
Yes. Generally, there is a contribution from people's pension, disability and support pension provided, and a component of that, generally 25% of the payment is rent, and then a component of that's for household expenditure.
And so across your various houses, can we make an assumption that the charge to the resident was notionally 25% to rent and the balance of the 75% for other reasons?
Sorry, so it's generally 75% of the person's pension,
Yes.
of which then 50% is retained for the household expenses and 25 for rent. Sorry, of the 75. Sorry. Yeah.
It seems a curious description to call that a rent component when you're in effect not paying rent in the traditional sense of that word. Can you explain to the Commission the thinking behind the allocation you just mentioned?
Well, effectively, my understanding is that the costs that might be encompassed in a rental piece is some of the functions that Active performed. So Life Without Barriers then collected the money from the pensions as per the agreement, and then we paid Active their charges, which on some years was correlated to the pension that we brought in.
I understand what you're saying, Ms. Roberts, but would you concede that just to describe the percentage taken from their disability support pension as rent is misleading in the ordinary use of that word?
I'm sorry, I don't know of what people generally think of rent. So I'm not sure if people think it covers those things.
Let me illuminate this, Robs. I think I can safely say that most people in the street, when asked, what rent do you pay, say, that's the amount of money I pay to the landlord for the right to live in my home. Assuming the residents and their families have that same understanding of rent that I've just described, wouldn't they assume that the percentage you ascribe to rent was being paid to someone else for the right to live in the premises?
I think if someone asked me that question, I would think that the rent also covered repairs and maintenance that would be required to be done to the premises. That would be something I would expect that would be part of the rental payment.
Okay. Did you also have a memorandum of understanding with Active Property Services Management?
Yes, we did, yes.
And you refer to that, I think, in paragraphs 28 and 29 of your statement.
Mm-hmm.
And again at paragraphs 269 to 272. And I believe a copy of that management MOU, Memorandum of Understanding, is in Hearing Bundle D at tab 17. Can you explain to me, under that Memorandum of Understanding, and by all means look at it if you need to, exactly the services provided under that MOU for the Melbourne House to Active Management? I'll give you a moment to turn that document up.
What services were provided?
Yes, exactly what did Active do for the money you were paying them?
Well, on reviewing the document, I am assuming that There are some general statements about the function they fulfill as the property manager in the main body of the document. And then there's a schedule attached, which is a list of services, really, that they would provide.
Okay. And if I can ask you to turn to paragraph 28 of your statement, and just read that paragraph to yourself. Does that paragraph encapsulate the main points of the MOU vis-a-vis you and active property services management?
I think so.
So they're asked to manage the property, provide 24-hour responsive maintenance. That's the equivalent of calling the plumber when the pipe bursts, correct?
I would assume so.
Conduct planned works and repairs and pay rates and utilities. I understand that, Ms. Robs. And it says active was not responsible for tenancy or occupancy management. That was the responsibility of LWB, wasn't it?
Yes, I assume so, yes.
And how did you strike the appropriate fee to pay active for the tasks they were undertaking?
I don't know that sort of particular detail. Sorry.
That's right, we might take that question on notice. Thank you. You then in your statement deal with maintenance and cleaning issues at paragraphs 146 to 155, and again at 268 to 289. I'm not going to take you to the detail of that, but you are aware that on occasions between 2016 and 2019, families of residents of the Melbourne house raised concerns about the cleanliness of the house.
Yes.
In setting out how HWB took steps to address these concerns, you outline in part at paragraph 148 of your statement. But in that part of your statement, you only refer to action taken in 2019 and 2020. Can we take it from that there wasn't any substantive response to the concerns between 2016 and 2018?
Are you able to just from which particular point in my statement? Sorry.
Yes, if you go to 148 of your statement.
148, thank you.
Well, it starts at 146 when it talks about repairs, maintenance and house cleanliness.
Yeah.
And you'll see that concerns were raised in 146, and then in 147, it enumerates further concerns raised in respect to cleanliness from A to G. And then in 148, you say Life Without Barriers took several steps to respond to concerns raised by families with respect to house cleanliness. And then you particularly concentrate on what happened in 2019 and 2020. And my question was, is the omission of any reference to 2016 to 2018 indicate that there was no substantive response to those concerns during those years?
No, definitely not.
What, to your knowledge, was done in the years between 2016 and 2019, or 2018 at least?
So in general, in that period. I can see in reviewing the documents, I can see lots of efforts from management of the house and several layers above the house to try to flag the concerns raised, try to respond, and try to, most importantly, incorporate some of the improvements, and perhaps cleanliness is a good example, into the day-to-day work, I think, in the house.
It would seem over the period of time from 2016 through 2019 at least, that those efforts weren't particularly successful.
I think, in reviewing the material, because we don't want families at all to be thinking that their loved ones are living in homes that aren't of a standard that they think they ought to be. That's not at all what we want. I think if I reflect on the effort I can see from the local staff, and yet the sense from the families that things haven't been addressed, I think one of the things that we have not been good enough at is having some structure and better process to feed back to families really clearly and promptly two things. One, what we're doing about things, because sometimes it takes a while to get things repaired. And secondly, when we think things have been repaired or addressed, and then get the feedback from the family. I can see that we have not done that well enough.
Is it the case, Ms. Robbs, that effort didn't necessarily equate with achievement?
I think effort didn't equate with satisfaction of the families and their concerns, which is disappointing.
But you're not suggesting that the level of satisfaction requested by the families was unrealistic, are you?
I think that if I use a small practical example, I think some of the requests were all fair and reasonable. I think some of the detail, like, I'm not stepping outside of my expertise too much, but the sealant in some of the bathroom tiles had become discoloured, and I appreciate that. So it wasn't so much a can we clean the bathroom task, it was a bigger task. So I think that it's not that the family's requests are absolutely reasonable, that's absolutely clear. I think sometimes the way that we did or did not articulate ourselves to families about what was involved wasn't helpful for them.
Ms. Robbs, I understand the difference between a repair and a renovation, but the residents are really only asking that the existing facilities be clean, irrespective of their age. That's right, isn't it?
Well, I think my example isn't an example of a renovation. I think my example is something where it could be perceived that if someone got in there with some stronger cleaning product, they might have been able to fix that problem. And what I'm suggesting is that that wasn't the case in that particular instance, but we should have still fixed it. But most importantly, we should have been more clear with the family about why we weren't able to do it as timely as they wanted.
You should have said to the family, we've tried, this is the best result we can get. No, I think we should have said to the family, this is actually what's causing the problem. Yeah. This is what we need to do to fix it. It's going to take a little bit longer, and we will keep you posted and we will tell you when it's done. And then we should have fixed the problem. Yeah. Can I move on to the question of resident selection and compatibility?
Yes.
You know that's been a major issue.
I do.
Compatibility doesn't simply involve finding people with similar disabilities and put them together, does it?
No.
It's a much more nuanced and sophisticated process than that.
Sometimes.
It is, or should
We've discussed the fact that initially the department selected the original residents, but I think LWB was then involved in replacing a resident that left, or indeed in suggesting that a resident might be moved to some other form of accommodation.
Yes.
What factors did LWB take into account when you were looking at the issue of whether a resident would be compatible with other residents? Explain the process you would go through.
Yeah, so I think there is some material in here, and some of it is on some guidelines and some checklists and forms that might be used to make that judgment. I think the level of detail that any compatibility is able to be done does depend on, as a number of other witnesses have spoken about here, particularly the witness from Victorian government, on the supply of houses at the time, residents at the time, and the demand for those to be, that's the practical reality, I think, that Ms. Congleton from Victoria expressed. So I think what we would want to happen is that we would want to have enough information to be able to assess the needs and goals and preferences of the person who may be eligible or want to move into the home, and then consider whether we can meet those needs, and then consider how that can be met within the home environment, particularly in regards to the other residents.
So we start by developing a profile of the individual concerned, particularly paying attention to their particular needs.
Ideally, yes.
Do you also look at previous accommodation they may have been in and what their history in that accommodation was?
In some instances, and I know that in the Melbourne house, some of that we would have known. In some instances, that's not always available, but ideally, it would be available.
Okay. So we do those two things and we come to a preliminary view that that person may be suitable.
Mm.
Do you then consult the existing residents and or their families as to the candidate you're looking at?
Well, we ought to.
Do you, in 2021, consult the families and residents in that situation?
I know it does happen, and I know I heard Mr. Doley made statements to that effect yesterday. So it is a practice. It's a known expectation. Yeah.
But specifically, if a vacancy arose in one of your houses today, as a matter of policy, would LWB have a process of consulting the existing residents and any family or guardian or advocate?
Sorry, as a matter of policy, yes. Sorry.
As a matter of reality, do you always do it?
I would hope so.
Do you have doubts that it's always done?
I think no, I think it's done. I just I think sometimes if people are really need the placement, I think sometimes that can drive decisions. Particularly, probably, sorry, just to finish quickly, particularly maybe in regional settings where the options are less, there's less options for people. I think we do consult, but I do think that pressure, it probably, is still present.
Now, I anticipate the chair may have a question, but before I turn to the chair,
No.
When did you start applying a policy of automatically consulting existing residents and family members as to a suitability of a potential resident?
I think at a policy level, it may have been there a long-standing statement. I think that has been made more specific over time and iterations of policy.
Ms. Robbs, when did you start doing it?
Sorry, policy or
No,
practice?
when did you actually start doing it on the ground?
So I think the reality will be that when the NDIS came in and people had more choice, that's when people actually were given more of a voice.
And when you say when the NDIS came in, what date do you have in mind?
Well, that varied across the
It did.
jurisdictions, sorry.
Strange about some of my questions, they have a reason behind them.
I'm sure. So, sorry. So it won't be one particular date in regards to practice, because as I said, really it's always the intention. It's definitely best practice and should absolutely happen. It's the practical reality of that, depending on the other options available for people in that particular town location.
Tell me the earliest date you started doing it as a matter of routine.
As a matter of routine, I don't think that would have happened as a matter of routine before the NDIS came in.
And when you say that, do you mean 2000 and?
From 2016, I
16.
think would be fairest. Yeah.
And so can we assume that between 2011 and 2016, that was not happening as a matter of routine?
I think that's a fair statement.
Why wasn't it happening from the very start?
Well, I think I've tried to answer that in saying that the pressure on the system for availability.
Now, with respect, Ms. Robbs, that's a separate issue. The Commission understands that in an individual circumstance, the need to give someone a roof over their head may carry more weight than other factors.
Yeah.
We accept it's a complex task.
Yeah.
But it doesn't, with respect, answer why you weren't consulting the residents and their families between 2011 and 2016.
Maybe I'm in trying to answer the question, maybe I'm misunderstanding consult. Do you mean speaking with before someone's right?
Saying to them, we have a potential candidate. We want to sit down and talk to you about who they are, what their needs are, to see if you have a view as to whether or not they would be compatible in this house.
Sorry, my apologies. Yes, I understand. I was misunderstanding consult in regards to decision making too.
So why wasn't it done between 2011 and 2016?
I think it probably wasn't done as a matter of like consistently because it was sensed that the decision making sat between government and a provider. I think that would be what I think was on people's minds at the time. And then when that started to change because there was more choice available to people, then I would say that practice, not only in Life Without Barriers but across the sector, probably then you would hope then increased. And certainly there's lots of examples in these case studies. There are examples, but also there's other examples in Life Without Barriers or my work where I know that's happened very actively with families and advocates and guardians.
You are familiar with the situation involving Katie in the Melbourne house and the proposal that she move into the Melbourne house after Stevie's departure?
Yes, I am, yes.
What inquiries did you carry out as Life Without Barriers in relation to Katie to try and assess whether she would be a suitable resident to move in?
So my understanding, looking at the material, is that Katie had already been living in another Life Without Barriers home.
She had indeed.
So therefore we were very familiar with her needs. And at the time, the home that Katie was living in wasn't meeting her needs. And so everyone in her support network was looking for an alternative. And the staff closest at the time felt like this would be a good option for her.
Now, in the document in hearing bundle D at tab 60, which is LWB.1026.0004.0026, and perhaps if that can be made available to the witness. Mr. Roberts, is this document a request from LWB to the Victorian Department dated the 27th of January 2014 to transfer Katie into the Melbourne House?
Yes, I understand it is.
I mean, describing Katie, it refers to her having been physically aggressive towards her previous housemate, including pushing and hitting. That's correct, isn't it?
Yes.
And so not only had she been living in an LWB house, but you were aware of that particular behaviour of being physically aggressive towards her previous housemate
Yes.
and pushing and hitting that housemate.
Yes.
There's then a tab 61 of hearing bundle D, which I'll also have provided to you, Ms. Roberts. And that's what's known as a vacancy profile.
Yes.
And that profile notes the needs and behaviours of each of the existing residents, correct?
Yes, sorry.
But it appears to make no mention of the prior trauma which was caused by Stevie's behaviours, that is the departing resident.
Yes, sorry, I'm just looking over it now.
Please take as much time as you need.
Yeah. No, it doesn't. It doesn't particularly call that out. No, correct.
And then the form suggests that it be noted any important dynamics existing between residents in the house that need to be considered when selecting a new resident. Can you see that?
Page 8.
I think so.
Is it page 8? Sorry.
I'll just get my instruction solicitor to assist you to.
What page of the document?
I believe it's on page 8.
Yes. That is, yes.
On page 8.
Yes. Yes, it is. Yes.
And that section, which asks to note any important dynamics existing between residents in the house that need to be considered when selecting a new resident, that's left blank.
Mm-hmm.
Life Without Barriers had information relevant to that question, didn't it?
Which piece of information? Sorry.
That the dynamics between the existing residents, you'd been operating the Melbourne House, you had information about the dynamics between the existing residents, and you had information about Katie from her former accommodation.
Mm-hmm.
There doesn't appear to have been anything put in the form relevant to the information you had.
No, that piece has not been filled out in the form.
Yes.
That's correct.
Then there are sections headed critical compatibility factors and preferable factors, which also seem to be blank.
I think it's a detailed form, and I think that the information that would be included is in the earlier parts of the form.
Well, in your statement at paragraph 75, if you turn to that, for the benefit of people listening, I'll simply read. I have reviewed the vacancy profile and note that it contains some sections which were left blank at the time of submission to the department, including sections of recording, quote, critical compatibility factors, unquote, brackets, e.g. aggressive behaviour, close brackets, and the, quote, rationale regarding compatibility, unquote. Then you comment, this falls short of my expectation around best practice. What did you mean by that comment of it falling short of your expectation around best practice?
Well, if there's a form that has sections to be completed, then it would generally be good practice for those to be completed.
Because this isn't simply a form filling exercise, is it? This is information critical to the existing residents and their families about the person who's being proposed to move in. Would you agree?
This form?
The information that
Oh, the
form
information.
asked, that the information it asked for was critical.
And the information. I mean, yes, I think the families of the existing residents probably quite familiar with the existing residents.
They are, but they're not familiar with the proposed new resident, are they?
No, no.
And that's the very piece of information they would like to know. Correct?
I think it's, I think it's absolutely fair that people want to know a level of information about people coming into the home of where their sons and daughters and family members are living.
Because you know from your experience of the world that when people share a house without disability at all, the first thing you want to know about someone that is proposing to move in is, what are they like? What's their background? What can I expect if they move in? That's all. It's trite to make that observation, isn't it?
No, I think it's absolutely fair that people want to know who is going to share a home with them. Absolutely fair.
And it's absolutely crucial that the department know that information as well, isn't it? Because this form is being submitted to the department.
Yes, you would hope that the form was as wholesome as possible.
And without that information, the department might think this is a good fit because there's no red flags being raised, correct?
I don't know. I think actually Ms. Congleton said there's a number of inputs they have to the placement process.
Yes.
So I'm not familiar with those at all, but regardless, you would want to have fulsome information submitted.
The department being involved in the decision-making would want to know everything that was relevant to their decision, correct?
Yes.
And that missing information would clearly have been relevant to their decision-making.
Which missing information?
The history of Katie and her behaviour in the other house, and any question of behaviours which might go to the question of compatibility with the existing residents.
So my understanding was that the form that you took me to, the first form, the supported accommodation service reconfiguration request form, I understood that also went to the department.
It does, yes.
Yep. Which does that does spell out in some level of detail Katie's needs and challenges.
Can I perhaps conclude this by asking you, are you satisfied in this particular instance with the information which was provided by LWB to the department?
I think I said in my statement I would have preferred for the forms to be fully completed.
Yes, you did.
Yep, so I would certainly stand by that. But I do feel like with the two together, there is quite sufficient information there to make a decision.
Yes, because one can be unhappy simply because a form hasn't been filled out completely, which is totally different from the question of whether or not you're satisfied all the relevant information was provided to the department.
Yes, yes.
And your conclusion is, based on your assessment, was that all the relevant information was provided to the department. Is that the fact?
Well, I think that I don't know the other sources the department have,
No,
but I think that in these forms,
just sorry to interrupt you, but are you satisfied that LWB provided all the relevant information it had in relation to Katie to the department?
I think so. To make the decision, I think so.
Can I move on to the topic of staffing of the Melbourne House? You deal with that issue at paragraphs 92 to 109 and paragraphs 119 to 131 of your statement. Can I ask you as a preliminary question, are you aware of a report from the Office of the Public Advocate in 2019 in Victoria titled, "I'm Too Scared to Come Out of My Room"?
I am, yes.
Have you read that document?
I've read the main parts of that document.
No. Do you have any recollection of what you learned from reading that document?
Well, I think it expressed people's experiences was probably the most impactful part from the document.
Yes. And you're aware that in that document, there was a suggestion that competency of staff members could be measured by a standard equivalent to, or in fact, a certificate for in disability.
And yes, I do understand that, yes.
Have you had the opportunity to look at what components are in the certificate for disability training?
I'm familiar with it to a level of detail.
And you know that support workers in the Melbourne House between 2013 and 2017 were required to have a Certificate 3 in community welfare or similar.
Correct.
Is there a particular reason why Life Without Barriers chose that level of qualification rather than the Certificate 4 or equivalent level?
I did hear the comments from the community visitors. I can't remember which particular visitor it was, who gave their understanding of the difference between the Certificate 3 and the Certificate 4. We held that view at the time because we felt that the duties performed at that direct level, the Certificate 3 was the most suitable sort of qualification, particularly for people who perhaps hadn't done a more of an academic qualification post-school perhaps before.
Could you explain perhaps in a bit more detail why you thought in the circumstances of the Melbourne House, Certificate 3 was more appropriate for those workers as a requirement?
I think it's not, the view at that time wasn't unique just to the Melbourne House. And the decision really was made on the fact that people that we often attract into the disability sector may not have completed any other training after school. And so a Certificate 3 really gives them the kind of an entry and the kind of basics and the framework, I think, to help them with their role, really, which is really what the qualifications should all be about.
So at that time, is it fair to say you took the view that you might run the risk of losing very, very good potential workers simply because they didn't have a Certificate 4?
No, I don't think that particularly would have gone through our mind, actually. I think it was much more about what would be really helpful for the workers and fulfilling their duties on the day. It wouldn't have been around us being worried about that. Yeah.
So you thought
I don't think so.
excuse me, you thought the certificate 3 was more applicable to the actual work they'd be doing.
Yes, at the time, yes.
Do you have a view in 2021 as to what the minimum qualification of a disability support worker should be?
I have a view that it's a vexed topic in the sector, and I know that lots of people with a disability would like their workers to be trained to a particular standard.
Mm-hmm.
I also know that lots of people with a disability and their families say that actually that's not really the point that makes a difference to them about what makes a good worker for them. And they would actually prefer workers that had things like common interests with the client, you know, someone that the client really liked and had a good relationship with. So I think that's a topic that we're grappling with in the sector. I think about, do you set a bar? Where does it sit for the people with a disability and their families to determine what workers they want to be able to have?
One advantage of having a minimum requirement is the world at large knows the benchmark, knows what that worker is expected to know.
Yeah.
If you don't have a benchmark, how do you satisfy yourself as to the extent of knowledge of a worker?
I mean, I think organisations like Life Without Barriers have lots of their own training, induction, mandatory modules, optional modules that they will provide workers with.
Mm-hmm.
I do appreciate the benefit of having a benchmark on industries, and I know that other areas that we work in, sometimes that does happen. In my answer before, I was just trying to share the kind of current debate probably in the sector around about what really matters. Yeah.
No, I understood that answer, Ms. Robbs, and I appreciate the distinction you make. Dealing with the Melbourne House in particular, we know about the Melbourne House in 2011 that it had residents with significant behaviours of concern and high support needs. That's a fair characterisation, isn't it?
Yes.
Would not a house composed of people with those characteristics require the sort of skills that a certificate 4 would have?
I think any education that people do is helpful. So yes, I would imagine that would be helpful in setting the minimum standard for us. We weren't remotely suggesting that people couldn't do more and higher. We were just trying to state what we wanted as a minimum.
I understand that, Ms. Robbs, and I understand your point looking at it from a sector-wide position, because there are all sorts of accommodation at all different levels.
Yeah.
I appreciate that. But I'm putting it quite specifically with the particular characteristics of the residents of the Melbourne House. That's at the upper echelon of support, really, isn't it? Unquestionably, surely.
It's in the complex end.
Yes.
Yeah. It's not at the upper end of support.
I understand the distinction you're making, but it's complex. And in those circumstances, my simple proposition is, wouldn't a certificate 4 have merits over a certificate 3?
I think, as I said before, there's always merits. Our intention was not to say that people couldn't do certificate 4. But I do think that we're still in Life Without Barriers in Melbourne and across the sector, really encouraging people into the sector. And certificate 3 is a good place to start.
Can I move on to the question of management of the Melbourne House?
Yes.
I take it you heard the evidence from Leonie Swift and Dr. Colleen Pearce particularly in relation to the results of numerous visits to the house.
Yes.
And at one point, they estimated that between 2011 and 2019, the Melbourne House had at least 10 different people in the role of either being team leader, disability coordinator, or practice leader positions. Does that accord with your understanding?
In preparing for this, I've spent quite a lot of time trying to really understand that, because because I understand the importance that people are placing on that, particularly for the families, actually, in knowing who to go to and who to raise concerns with. We definitely did make structural changes at a couple of points in time through those years, whichever period you're referring to. The other piece I just put in there is my observation from reviewing particularly probably the documentation and the email communication and such, is that we didn't so much have lots of new people coming into roles. What we did have was people that were there in roles changing roles. And I hadn't really appreciated that quite as much until I reviewed the material. So I can better understand now why, from a team perspective, management's perspective, it didn't feel like lots of turnover, because they would have had the same people working in the same team in Melbourne. But from a family perspective, it would have felt like that, because different people were doing different jobs through that time. If that's a helpful observation.
Chair, I should correct the record. I indicated that estimate of 10 different people came from Dr. Pearce and Ms. Swift. In fact, it came from investigations carried out by those that instruct me. So that's a conclusion reached by the Commission on the basis of analysis of the document. And rather than being simply a question of people changing role, it identified 10 different people during that period of time in those various roles. Having made that correction, Mr. Robbs, can you tell me from your experience what the effect upon residents of a high turnover of management can be, and on their families?
So I think on their families, because that's just been so clearly expressed by particularly Paul Rebecca. No, sorry, my apologies. I'll come back to it. So for the impact to the residents, firstly, the most important thing there is the stability of the staff in the house.
Mm-hmm.
And that is absolutely the most important thing for the residents. So the impact to changes in supervision over the house will be in regards to the consistency of knowledge of the residents, so that people can give good advice to the staff about how to support the residents as best possible. For the families, I think the main challenge will be who to go to, but most importantly, the relationships. So who do the families have a relationship with? Who are they building a relationship with that they can go to with concerns and know that that person understands their family member and will support the staff to best care for them.
Would you agree that your answer is encapsulated what Catherine said at paragraph 38 of her statement, where she said, there were some good managers who did their best, but it always took them a while to get up to speed and to try and put things in place to assist. And then they'd be gone and we'd have to start again. Does that pretty much sum up the sorts of difficulties that arose?
More articulate than me, yes.
And Leonie Swift from the Office of the Public Advocate at paragraph 77 of her statement, made this observation. Continuous changes in the operational managers responsible for the house meant that when we, that's the visitors, got some traction in resolving a particular matter, we would then find ourselves back to square one. It was very frustrating. Would you accept that that's a possible consequence of a high turnover of management?
Definitely.
What steps do you currently put in place in LWB to try and get more stability of management of houses?
So at that sort of local level, which is the most important level for the people that you're speaking about there. One of the things we're trying really hard to do is to run things more from a team perspective rather than just a particular individual, so that we have got not too many, because you don't want too many people knowing people's personal information or things actually that causing confusion, but more than one person or two people really familiar in that local team with the residents, the staff, the families, the current issues. And in that way, we're hoping that firstly, there's a few points for family members to go to. Secondly, it'll be smoother when people go and leave, or when there's reasonable, reasons why people aren't present in the organisation, but also when people do leave the organisation, that it's not as disruptive to people. It's just a practical thing we're trying to do.
Can I now move to the issue of the use of casual or agency staff?
Yes.
Mr. Griffin, I noticed that the program, I think, called for us to break at about 12:30. I'm not troubled by the specific time, but
I wonder,
how long would you like to go before we break?
I'm happy to break now, but I wonder whether I might give commissioners an opportunity to ask any questions.
If you
today.
prefer to continue for a little while, subject to Ms. Roberts being comfortable, then we can do that.
I can certainly go through to 1 o'clock without any difficulty. But I'm
Are you
conscious
comfortable, Ms. Roberts?
I'm happy to continue.
Will that help us in finishing today, if possible?
I think it will, because I think it'll be a section of evidence I can probably
Well,
complete.
perhaps we might continue and then give commissioners an opportunity just before 1 o'clock to ask questions.
Thank you, Chair. As a general comment, the use of casual and agency staff, do I correctly understand the position of LWB that you've moved significantly between 2011 and 2021 to reduce the percentage of agency and casual staff?
Yes.
What's been behind that move to try and reduce the percentage of such staff?
Why do we want to do that?
Yes.
Particularly because the circumstances for casual and agency are quite different. So if I take agency staff first, that's helpful. So agency staff are very helpful in a circumstance that is more short notice and critical, because we've not been able to have a consistent staff member come on shift. And I do appreciate and respect that. And they're really good people, do a really, really great job, undoubtedly, and under quite difficult circumstances often. But they're not Life Without Barriers staff. And so even though they are good workers and they're often very experienced and often do know a lot of the participants, we would really, at the end, we'd really prefer for people who have made a decision to come and be a Life Without Barriers employee, who've gone through induction and training and a part of our culture and values and the way that we want to provide care. So that really was the driving force behind us trying to really reduce agency staff. Again, not about the individuals themselves, but about the way that we want to provide care. Casual staff is a bit more complicated because some people who make really fantastic workers actually only want to be casual. But we have been working hard, again, similar driver, to say that you look in a house, you want to have some permanent, stable staff. You want to have some casuals there, so there's flexibility, and we don't want people that are really good workers not being able to come to the organisation, and you want to use agency staff as an exception really only.
Can I put to you an impression formed by Ms. Barbuto, who was one of the community visitors in 2013? She observed that staff retention at the Melbourne House was affected by the constant violence at the house, and that staff may not have felt sufficiently supported or equipped to deal with that situation. In reviewing the Melbourne House, do you accept the proposition that there seemed to be quite a high level of violence, firstly resident to resident, and indeed some incidents between resident and staff?
I think that there is no doubt that the Melbourne House was a very busy, complex environment for in this instance, we're specifically talking about workers. There's no doubt that it was a very busy home that taken. Whether that then contributed to staff turnover, I couldn't say. I mean, I do understand that staff can work anywhere. And I do understand that sometimes perhaps doing a shift in a house that's more complex is more challenging, and people may prefer to do less challenging work. But that's really more of a generalised comment than specific to this house. Yeah.
When support workers employed by LWB decide to leave the organisation, do you have an exit interview process?
We do, yeah, we do. It is optional, but we do have one.
Ms. Robbs, I think the question that Mr. Griffin put to you, question before last, was in reviewing the Melbourne House, do you accept the proposition that there seemed to be quite a high level of violence, firstly to resident, and indeed some incidents between resident and staff? Your answer referred to the Melbourne House being a very busy, complex environment, but I'm not clear that you actually answered Mr. Griffin's question. So do you accept the proposition he put to you?
Sorry, I was answering whether that impacted on staff turnover. My apologies at the
Don't worry about
time.
apologies. I just, what's your answer to the question?
About whether the Melbourne House had a high degree of...
High level of violence, firstly resident to resident, and indeed some incidents between resident and staff. Do you accept that proposition which was put to you by Mr. Griffin?
I think that I would say back to that any level of violence is not an acceptable level of violence, in a home. No violence is acceptable at all. So it's difficult for me to comment on that degree. Would be my first statement, and I'm agreeing that it was a house with people with complex needs and a demanding place, I'm sure, for people to work.
I'm still not clear whether the answer to the question is yes or no. Do you accept the proposition?
I think I'm challenged by the proposition that any violence is acceptable. It's hard for me to say that. Yeah.
Perhaps if I qualify the question by saying this, compared to other houses conducted by LWB with similar residents, did the Melbourne House have a high level of violence, resident to resident, and occasionally resident and staff?
I think it's not a particularly challenging home outside of other homes, people with similar needs. No.
Let me put it this way. Did you ever engage in the exercise of doing a profile of your houses to see if they had similar characteristics when it came to the level of violence, just in order to identify whether there was a particular problem in one or other house?
Yes, we have definitely looked at incidents and whether there's a link around incidents, complaints, property damage, etc. That would be indications of houses that maybe needed particular extra support. We've definitely done those exercises before.
Well, I'll come to that issue very directly, but before I do, Ms. Barbuto, in her evidence at page 287 of the transcript on the 9th of December, said in part about the Melbourne House, there were times when the house was completely staffed by casual and agency staff with no call worker present and no house supervisor present. There were periods of time when the program manager position was vacant. Assuming what Mr. Barbuto says is correct, can that ever be acceptable in your eyes?
Well, the program manager piece is a bit separate. It's more of a senior management role. But would you want a situation where you had just casual staff and agency staff in a house with people with complex needs? In essence, some of that practically would depend on whether the agency staff were the casual staff, were long-term casual staff, because we assume sometimes that casual staff means we're just sort of drop in for a few shifts, but actually people can be casuals for a long time. So you would want permanent staff on, and that's always our goal. But in some instances, if it had been casuals that were known to the residents and had worked in the home before, that would be different than if people showed up on the day, which is obviously completely unacceptable.
I want to suggest to you, Ms. Robbs, that the only sensible answer to that question is no, it can never be acceptable. Do you agree with me or not?
No, I don't.
Thank you. Can I come to the issue of incident reporting of resident-to-resident conflict and violence?
Mm-hmm.
Can I indicate to the commissioners that we did not ask Ms. Robbs to answer detailed questions in her statement about resident-to-resident conflict and violence at the house prior to May 2014, when Katie moved in. So I don't propose to concentrate on questions before that time. But Ms. Barbuto had been visiting the house since 2013, right through until the present. And she gave evidence about a high level of resident-to-resident violence. There was also evidence given by Catherine and Paul to the same effect. You accept that, don't you?
Yes.
In light of that evidence being given from the two individuals and the community visitors, do you accept that the Melbourne House was either typical of your houses in that respect or unusual in respect to other houses you're familiar with when talking about the level of violence?
Typical or unusual? Well, sorry, I appreciate what you're trying to ask me. I'm just really struggling to use those terms to characterize any violence in the homes. Sorry.
In preparation to give evidence to this commission, did you familiarise yourself with all the records LWB held in relation to violence at the Melbourne House?
Yes, I did, yes.
And when looking at those records globally, did you form a view as to whether the level of violence being reported seemed out of the ordinary compared to other homes that you controlled?
So when I review the information on the incidents, and I consider the residents in the house and their needs, then I can see the efforts around supporting people with their behaviours of concern. But I can still see that incidents occurred, and one is always too many.
In question, we gave you a notice to give a statement in writing to this commission.
Yes.
In relation to question 35 of that, we asked you to indicate how many instances of resident-to-resident violence, abuse and or conflict were recorded by LWB in the House between the 1st of May 2014, from the 1st of May 2014, in accordance with any LWB policies outlined, etc. And we asked you to provide the date of the incident, who was involved, description.
Yes.
As a result of that, you provided to us an Excel spreadsheet which appears at hearing bundle D of volume 4 at tab 320. Do you remember doing that spreadsheet?
Yes.
Now, Commissioners, I can't bring that spreadsheet up on screen for technical reasons. But is it the case that the information you provided to us turned out not to be complete?
It did, yes.
And on the 13th of December of this year, did your solicitors write to the Commission indicating that you'd identified 7 additional incidents of resident-to-resident violence, abuse and or conflict, which were recorded by LWB in accordance with its policies in the period from the 1st of May?
Yes.
And did you then instruct your solicitors to tell the Commission that these additional 7 items were not captured by the searches that have been conducted?
Yes.
And that the incidents recorded in hard copy documents, which were not migrated onto the iSight, that's I, capital SIGHT, when you transitioned to that system of recording in December 2017.
Correct.
And are you aware that the Commission responded to your solicitors on the 13th of December, identifying a further 8 incidents which we thought may have been relevant to the request we made to you?
I am, yes.
Are you aware whether there is any response to those additional 8 matters which we've highlighted?
Sorry, I haven't had an opportunity to
Okay.
review that, sorry.
That suggests, Ms. Robbs, that the ability of LWB to identify reports of violence in 2021 is deficient. Would you agree?
I think the additional matters that have come from the Commission to us before, I haven't had a chance to review, and I'm not sure if any of them were before 2017. Sorry. If they were, then I think that would be a similar migration issue where we made some decisions around what we would and wouldn't migrate into the iSight system in 2017. If there are matters on that list that you provided that are since 2017 and ought to have been reported into the iSight system, then that's very disappointing, because we work really, really hard to make sure that people know how to use the system, what to put in the system. We've tried really hard to make it easier to use. And so it's important to us that the incidents do get into the system, because that's what then triggers all of the action.
Ms. Robbs, the question you were asked
was as follows. That suggests that the ability of Life Without Barriers to identify reports of violence in 2021 is deficient. Would you agree? I wonder if you'd mind answering that question directly.
Sorry, not without reviewing that information and understanding a little bit more. It'd be difficult for me to make such a broad-reaching statement just on that. Sorry.
Why?
Why would it be difficult?
Yes, why is it so difficult for you to make a general conclusion? You're putting, are you, that if this happened, it must have been an isolated incident and would not be replicated in any other places?
I would be saying that if it happened, it would be more an isolated incident. That's not 100% guaranteeing it could never happen again, but that's not accepting that the generalization at all.
How would you know that it might be an isolated incident rather than a general systemic problem?
So when we do have an instance where we're aware of matters, and like this is what we will do if these matters are in that category, then we try to understand why it was they weren't on the system. Was it people didn't understand? Was it they put them into the system wrongly? Then we think about, well, is there something we need to do either for extra training and awareness, or do we need to, at the moment, for example, we're putting the system onto people's phones because we're hoping that that's easier for people to record rather than having to go on the system, onto the laptop. So we try really hard to respond if anything like that happens, which is why I would say that it would be more the anomaly. We also do monitor the number of matters so that we can see if anywhere's got a little less matters than we would expect, and if that's the case, then we would get our quality team to interrogate that and see if there's anything in there that would be of concern.
Chair, I wish to move on to the topic of access to reports given to the community visitors. I wonder whether this might be an appropriate opportunity to ask commissioners whether they have any questions.
Yes, certainly. Commissioner Galbally, do you have any questions at this stage for Ms. Robbs?
Just a question to clarify whether I understood you properly. So you didn't, I thought you were saying that the level of violence, lateral and to staff, wasn't, there were other examples in the LWB, group homes around Australia, that this wasn't the only place where that occurred, from your knowledge?
Yeah, I think what I'm saying is that in my experience and looking at the material, with people with needs similar to the needs of the residents in Melbourne, reason that the Life Without Barriers and the whole sector has an approach around behaviours of concern and positive behaviour support and active support is because we're always trying really hard to reduce those incidents. And so those incidents can therefore be present in other homes managed, can be present in other homes managed by Life Without Barriers and across the sector.
Do you, after all your years of experience in this area, do you have a view as to the actual suitability of this model for people with, tendency to get frustrated and about other people as well as environments? Is there a better model in your view in terms of numbers and staff ratios and even stimulus, in interests?
Yes, and I think Mr. McNaughton in his statement used the word contemporary models. I think that that where we're able to have housing that is more purpose-built to enable people to have more personal space, but still balance up the access to staff support so that we can have that balance better. I think that's been proven that can be really, really successful for people, even with quite complex, behavioural or medical needs. So different models that enable them to have more personal space, probably. So things like small units together, or units that have staff on site but not there all of the time. And then probably smaller groupings. I think this came up, Commissioner, in regards to Sophie. And her experience now, when she's actually just sharing with one other person, only one other person that has quite similar needs to her. And it's really clear that her funding's been adjusted to allow her to only have to share with one person. She's sharing with someone that she's got really compatible likes, and appreciate her parents said it wasn't perfect, but it sounded good. That's obviously a great situation for her to be in. So I think there are other models, and I know there's more and more coming, through the NDIS and SDA and all of those housing models that you would think would be more suitable for people with really complex needs.
Thank you.
Commissioner McKeown?
No, thank you.
Thank you. Is this a convenient time?
Yes, Chair.
All right, it's just after 1. If we resume at 2, will that give you enough time to finish? Yes, we'll resume at 2 p.m.
The Royal Commission is adjourned. The Royal Commission is resumed.
Yes, Mr. Griffin.
Thank you, Chair. Ms. Robbs, I want to take you to issues surrounding the witness Natalie. Can I ask you to look at Mr. Doley's statement, commencing at paragraph 288. And you'll see at paragraph 288, on the 18th of February 2015, the Life Without Barriers Director of Operations, New South Wales ACT, was notified of, omitting that name, conduct towards Natalie. Can you see that?
Yes, I can, yes.
It then goes on to describe what happened with the notification. In paragraph 290, notification of the Chief Executive Officer. Do you recollect receiving notification concerning the conduct of Natalie?
Sorry. At the time, because this was pre-eyesight, this matter, I would expect this to be notified verbally. And as it says in my statement, I'm not able to find any documentation. Yeah.
And you don't have a particularly strong recollection of that matter?
I was aware of the matter before this hearing, but it's hard for me to know now that I'm immersed in the information. Yeah.
If I can ask you to turn to paragraph 294 of Mr. Doley's statement.
Yes.
You'll see a heading, Notification of Board Risk Management Committee.
Yes.
Do I take that paragraph to mean that when the notification in relation to the conduct of a staff member in respect to Natalie came for board consideration, it was allocated to the Board Risk Management Committee because of its insurance nature?
Yes, possibly. Yes, I'm not sure of it. Can't remember if it was in the report as a legal matter or an insurance matter. Yes. Sorry. Yeah.
And so when it was notified to the Board Risk Management Committee, am I correct in assuming that the committee was considering the details of this matter from a legal stroke insurance ramifications point of view?
I think not an insurance point of view, I wouldn't think, no. When those matters, when matters come to the risk committee, the discussion with the committee is usually more around the context and content of the matter, what we've done in response, what hasn't, and so what's at play for the organisation. There's not. Insurance doesn't really feature really in the discussions with the board.
Were the events surrounding Natalie notified to your insurers?
Yes, my understanding is they were, yes.
When the board became aware of those events, do you know if anyone within LWB provided advice to Natalie or her family that she was entitled to seek independent legal advice?
On my review of the material, I don't think we would have done that.
The circumstances were, it was alleged that an employee of LWB had assaulted Natalie.
Yes.
If that situation arose today, would either you or the board ensure that a resident was advised that they could seek independent legal advice as to their position?
I know that if that was to happen today, we would talk around, we have the redress policy that would be relevant. The independent legal advice, I'm sorry, I'd need to take that on notice, actually.
Well, if somebody has been the alleged victim of an assault, you would understand that they may have legal options available to them.
No, absolutely. And I'm not suggesting that we don't do that. I'm just suggesting that I can't assure you with any level of precision enough sitting here today. I would hope that we would, but I can't provide that assurance today.
Well, shouldn't that be in one of your policies, should those events occur?
Yes.
Because one can't be certain that a resident has family members, can you?
No, it should be.
Yeah. Did you or the board make an apology to Natalie when you became aware of what had happened to her?
No, we didn't, and we should have.
Did you consider apologising to Natalie on behalf of the organisation for what had happened to her in the house?
We have our active apology policy now, but at the time we didn't take that action. And hopefully I was clear in both my statement and in my apology that we ought to have.
And briefly, what is your current, to use your words, active apology policy? What's the gist of it?
Well, the gist of the policy really is that when there's harm or an event occurs where we ought to apologise to the person receiving support and or their family members, then we proactively offer that apology in a form that's helpful for the person. Sometimes that's writing, sometimes that's in person, and we do that in a proactive way.
Can such an apology include an offer of some sort of financial or other redress?
We do have a redress policy around people with a disability that we are working on just now. We do have we're part of, the scheme around children in care as a result of the Royal Commission several years ago. And yes, we would provide that information to people in giving the apology through the active apology process.
If the resident didn't qualify for the current scheme, which arose out of the Royal Commission involving the sexual abuse of children, would your proposed policy offer the same range of redress that the other scheme offers?
Well, I think one of the challenges that we have is that the scheme for children that you're referring to has some clear responsibilities, clear decision-making processes, guidelines, etc., set across the country that we then adhere to and are part of. It's much more complicated for us to do that as a single organisation, but we are working out how we can do that without some of that decision making that at the moment does sit outside of Life Without Barriers, because it sits within the scheme, and that provides us with really good guidance, which isn't my understanding isn't present for us at the moment with regards to adults with a disability.
Well, if you have an adult resident in one of your homes who suffers as a result of the conduct of a staff member in the way Natalie did, why is it complicated to offer them some sort of redress which may include financial compensation?
Well, I think that the complication is possibly why there are so many guidelines and processes in place for children, because determining the means by which you will award the compensation, the amount of that, the process around that, there would be definitely some complexities in there, which is why my understanding is that some of that decision is made by government, so there's some consistency across the country. We wouldn't have that support in this instance. Yeah.
Why couldn't the board of Life Without Barriers, in an individual case, decide to make an ex gratia payment to a resident in recognition of what they'd suffered?
I think I'm not suggesting that the board we wouldn't want to do that. Otherwise, we wouldn't have the active apology and the redress policy. I think the challenge that we're still grappling with is the mechanism to determine the entry, the eligibility, for want of better language, and how we would possibly determine value of any redress. And we are provided with those directions by government, and they're consistent across the country for children. And we just don't have some of those guidelines, which, yes, means that we would have to make those decisions, and that's complicated.
Well, I want to pursue that if I could. In the apology you read out this morning, you said, for Natalie and her family, the sexual misconduct by a staff member is completely unacceptable. And I acknowledge the pain and trauma this has caused Natalie and her family. Our priority should have been to act earlier and protect Natalie. I offer this apology to both Natalie and her family with a full understanding that our delay in offering a genuine and human response was also unacceptable. I recognise the pain and fear that Natalie must have experienced during the acute episode in relation to her bowel care, about which the Commissioners heard evidence. In light of that apology, why wouldn't the board of Life Without Barriers today sit down and say, we're going to supplement that apology with some tangible redress to acknowledge the things you've apologised for? And why couldn't the board do that on an ex gratia basis without having to have a scheme in place?
So with the policy that we have at the moment, then people can approach us, and there is the capacity and the decision making in the organisation to make those decisions. And sorry, I may not have been clear. I'm not suggesting that's not open to Natalie and her mother. I was more addressing the query around a more broad redress scheme across the organisation that has some more of those structures in place.
I understand
Sorry.
that, but as
Yeah.
you're speaking to me now,
Yeah,
you can't think of any impediment to that happening.
no.
Thank you.
Ms. Robbs, you've been asked questions about what happened to Natalie. It wasn't just a question, was it, of her being assaulted or her integrity being violated.
Mm.
Investigations by Life Without Barriers resulted in findings that 2 members of staff played a part in allowing this to occur. Is that correct?
Yes, that is correct.
Isn't it pretty obvious that in that situation, that Life Without Barriers has committed a serious breach of a duty that it owed to Natalie?
Yes.
The normal consequence of a breach of duty, if someone chooses to take action, of course, will be, in the end result, a form of compensation. You agree?
Yes, I would, yes.
When you said that you're not sure whether Natalie was ever given advice or her parents given advice to seek independent legal advice, are you suggesting that you think, based on your analysis of the documentation, that there is a significant possibility that that actually occurred?
That they were given that advice.
Seems wholly unlikely.
Yeah,
doesn't it?
I think not.
Yes, exactly. And are there minutes of the Risk Management Committee as a matter of course?
Yes.
You looked at the minutes of the Risk Management Committee that dealt with the Natalie case?
I have, yes.
And what do they say about what happened at the meeting or meetings that considered Natalie's case and perhaps considered the role of an insurer? Do you remember what's in those documents?
Sorry, I might have to have a look at them again if possible.
It was relevant, wasn't it, to the statement you were preparing?
Yes, definitely.
All right. Well, no doubt in due course, one way or another, that document can be obtained, or there may be more than one document. Yes, thank you, Mr. Griffin.
Chair, it may be the document LWV.007.001.1298. I'm currently having my instructing solicitor turn up to see what that document contains.
Thank you.
Chair, there's an executive summary of the document. It will take some time to digest because it contains a number of matters.
That's fine.
Ms. Robbs, do you recall the evidence of Dr. Pearce, the public advocate for Victoria?
Yes.
As we currently understand your evidence, descriptions of resident-to-resident violence would not, as a matter of routine, be reported to the board. That's correct?
Sorry, I'm just not sure when you say descriptions of resident-to-resident, what that really means.
Individual incidents of resident-to-resident violence would not currently be reported to the board?
The board reporting has understandably changed over time. At this point, current sort of point, individual incidents are reported through generally in a aggregate sense with a categorization, and then there are discussions at the meeting around particular points or highlights that both the management may want to make to the board, and also questions obviously from practice committee directors around any particular matters that they have questions around.
So does someone within LWB gather together all the reports of resident-to-resident violence and make a summary for the board?
So we, my understanding is that we gather the reports from our eyesight system, and the quality assurance team and risk team extract the information and prepare the reports, and then our service delivery executives, or we would call them client services directors, then prepare the narrative or context explanation for the matters and the facts in the report. And then both the client services directors, myself, and the director for quality and risk all attend the practice committee, so that the members are able to talk to both the people responsible for the matters, but also the quality assurance and risk executive.
So that reporting goes to a committee of the board called the practice committee.
Practice governance committee, actually, yes.
How many board members sit on that committee?
And the board, that committee is chaired by one of our board members, and there are 2 other members of the board on that committee as we are today, and there are 2 external members of that committee as we are today.
And for how long has that process been in place?
The practice committee started in 2014 in a slightly different format. We had different external members. May or may not have started by then, but the actual practice committee from a governance sense started in 2014, I think.
How long has the committee been receiving the information you described in summary form?
I want to say several years, because the information has changed in the way that it's provided. So it won't have been in its current form, but for a period of time, but in a different form, but similar information over several years.
Several meaning 2 or 3?
Possibly.
So from about 2019?
I tend to go a little bit earlier than that, because one of the things that really helped us do that was the eyesight system.
Which was introduced in 2018, I believe. 17.
Yeah. So I would probably just a little bit earlier than 19, I would think.
So from some time after eyesight was introduced?
Yeah.
And prior to eyesight, were any such summaries made available to the board or a board committee?
Sorry, I couldn't be completely clear back before 2017, sorry.
Do you accept the evidence of Dr. Pearce that the level of resident-to-resident violence is a key indicator of the standard of care within a house?
It's definitely an indicator in the house, but I think there's other factors that impact upon those matters, the particular needs of the individuals involved, the complexity of their needs, etc. So
I appreciate that, but my question was, do you accept that the level of resident-to-resident violence is a key indicator
of
standard of care within the house?
Yes, it's definitely an indicator.
Now, such violence is not only a concern for LWB, but it may also involve the police. Is that right?
Sometimes, yes.
Can you briefly tell the commissioners On what occasions do you expect staff to involve the police? And on what occasions do you believe that a threshold of police involvement is not reached?
So we would generally expect staff to call the police if there was an imminent danger to residents and or staff that we know was of the form that the police could help with. If there's a crime, we would expect staff to call the police, and really if it's a matter that the staff member feel the police are going to be the helpful source from the community for them.
So I'm still not clear on where the threshold is. Are you saying if a crime has been committed, you would involve the police?
I think if there's a crime has been committed, we would want that reported to the police. I think the threshold is difficult because sometimes that is the individual decision or of either a staff member or a group of staff members around how they are sensing the situation is in regards to the need for the police to attend. So it's we've got guidelines on it and it's listed a number of policies and procedures. It's difficult to be too prescriptive because people do need to use their judgment in the moment.
So you indicate in paragraph 304 of your statement that during the relevant period, any alleged criminal acts were to be reported to the police, as you've just said.
Yeah.
Are you able to tell the Commission whether all such incidents were in fact reported to the police?
Sorry, could you just give me that number again? Sorry, for my statement, sorry.
Yes, paragraph 304.
4. Yes.
Perhaps I can give an example.
Mm-hmm.
From our examination of the documents, police were called in the following circumstances.
Mm-hmm.
On the 2nd of January 2015, after Katie punched Marco, threw a picture to the floor and punched a cupboard door that appears in hearing bundle H at tab 29. Similarly, on the 9th of January 2015, police were called after Katie punched Amanda in the mouth, hearing bundle H, tab 30. And on the 29th of March 2017, police were called after a fight between Katie and Marco, during which Katie punched Marco and he tackled her to the ground, hearing bundle H at tab 131. So they're examples which seem similar where police are called. Do you agree?
Yes.
And they appear to involve what could be classified as a criminal assault. I don't want to get into technical legal things, but they were all assaults, let's put it that way.
I think it sounds like they were appropriate for the police to be called. We don't really look at those behaviours in that sense of a perpetrator and a victim at all.
Except to say that you did say in an earlier answer that a threshold was whether a crime had been committed.
Oh, absolutely, but that doesn't necessarily mean in the moment of a behaviour of concern. That could be anything from fraud or any crime.
I understand all of that. So I've given you 3 examples where there appear to be assaults. But on the 8th of September 2018, an incident involving Katie dragging Rebecca along the carpet and pulling out her hair, no report to the police.
Mm-hmm.
after the February 2019 incident between Katie and Marco, during which Marco hit Katie with a chair on 3 occasions and broke her finger, the community visitors queried why the police had not been called. What I'm trying to understand from you is, how do you draw the line between when you involve the police and when you don't, under your policies?
The policies do set out, as clearly as I think is possible, the circumstances that we would want staff members to be calling the police on. Then, in a practical sense, on the ground, in the home, in that moment, then advised and informed by those policies and their training, staff members then use their judgment. And for the matters you just referred there, it's difficult for me to comment. I wasn't in the home at the time.
Well, on their face, those 5 incidents seem to have the same sorts of characteristics, and yet 3 involved the police and 2 didn't.
Well, I would say that I appreciate that, and the information we have, that might look to be the case, but in those instances, it shows that staff members do make decisions to call the police on the instances you've explained, and not in others. So I would suggest then that there could be a difference in those that's not immediately obvious, perhaps, when reading some of the documentation.
I appreciate sometimes a decision has to be made very quickly.
Yeah.
But if a staff member was unsure, who would they seek advice from?
So if the staff member themselves was unsure, they may have a colleague that they can work through that together with. If not, then they would have access to on-call that they could work that through with, or they could phone their manager or the office, and if in doubt, they would make their best decision.
And is that set out clearly in the policies?
I'm sorry, I'd need to look at whether it's in the policies or perhaps a procedure or protocol it might be, because that's a little more operational perhaps than maybe any organisational policy document. That may sit more in a guideline, or maybe in the policy.
Okay. Can I move on to the question of community visitors in Victoria?
Yes.
Just before you do, I just wondered if I could ask you what was expected the police would do when you just said there's no perpetrator and you don't want to see it that way. So what's the hope from the police when they're called?
Yeah, I think that's why we particularly encourage and want staff to phone the police when there's imminent harm, that the intervention of police and the presence of police will keep everyone more safe. And that's not in every circumstance where there's a behaviour of concern at all, because for lots of people, the police may actually escalate the situation, not through their actions intentionally at all, but just by means of escalating everything. Yeah, and if there's the presence of a crime, which I use that language, I did not necessarily mean in the context of a behaviour of concern. I actually meant other crimes that might occur. It's not usually helpful, in my experience, to use the police to try to support people to calm. Sometimes it may be, but not often. And it's certainly not, in my experience, particularly helpful to use the police as an education or skill building to support people to manage when their anger and frustration builds. That really sits in a clinical environment and sits with the clinician and their support staff and their families, not with the police. And so that's why, even though we absolutely want people to call the police when they feel at risk and they feel that the police intervention is needed, we don't see them as an educative tool for people who are just struggling really hard to manage their anxiety and frustration.
Thank you.
Can I follow up Commissioner Galbely's question? I asked you earlier in your evidence whether you're familiar with the report of the Office of the Public Advocate entitled "I'm Too Scared to Come Out of My Room," and you indicated you were.
Yes.
At page 22 of that report, it notes, and I quote, "Violent behaviour perpetrated by and towards persons with disability is not always labelled as violence. It is instead often dismissed as behaviours of concern or put down to resident incompatibility." Do you have any observation on that part of the report in light of what you've just said?
I appreciate that extract and that being the review. I also, from my experience and this role and beyond, have a strong view that our role in people's lives is to support them to live the best life they can, and to acknowledge that a lot of the people that we support come with complex needs that impact on their ability to manage their stress and frustration that we all have. And yes, I understand that sometimes that does come out in behaviours that can be harmful and sometimes deemed violent. I appreciate that, and it's not okay. I understand that. But it's also the person doing their best to manage that with the support of the people around them. And I don't think it's helpful often for us to characterize them as perpetrators. They're people trying really hard to make it through life. And in that moment where the behaviours of concern escalate, and I understand the impact to other individuals is not okay. And I understand, I do, and I respect that. But for that individual, it's one moment in that day or one moment in that month or that year. They are well managing with support of their network those same anxieties and frustrations for every other minute of the day. And I don't feel like we should characterize or label people on the moment where it doesn't go right for them in life.
So in part, Ms. Robbs, are you concerned that an incident might end up with a resident in the criminal justice system in circumstances where it may have been managed in a different way?
Oh, I think that would be I can't think that would be a good outcome for people.
Now, I appreciate
at all. It's the labelling. It's
Yes.
that I don't think.
And I understand
helpful.
the perpetrator may well engage in conduct because of various behaviours they have or frustration. That's accepted. But what about the rights of the victim of that violence who has to continue to live in the home with the perpetrator? How do you factor in their rights?
Yeah. I think, when I spoke to that in my apology around Rebecca's goal of having a goal in your plan, which is to feel safe in your own home. I know that's not okay. So it's a challenge for all of us to balance that up. I'm just suggesting in my comments to the extract that you read out that it doesn't feel right to jump then to violence and perpetrator mindset and language. I would like to think that there's a better way for us all to support that and protect people's rights of the others people in the house, which I absolutely respect.
Well, I want to suggest to you, Ms. Robbs, a better way. If we didn't label people as perpetrators, but instead saw it as being resident-to-resident violence, being recognised as a violence, and reported as such up to the LWB senior management, they could then address the issues of how to address it. Wouldn't that be a model which would work more effectively?
Sorry, that is the model.
Well, do you say that that model was applied to the Melbourne House from 2011 onwards?
I think that the model where incidents are reported up the line so that they can be, the people involved in those can be as best supported as possible. That is the model. I think that we have tightened and improved and continue to improve that through the organisation and the sector. But that would be the intent of us knowing about incidents, is to learn from them and try to make sure that people have the right support around them, so that they, so that they're as best supported as possible to manage those pressures that build up in them.
Let's assume that's correct. When Ms. Barbuto, in paragraph 26 of her statement, describes how she's been a visitor at the Melbourne House for a long period of time, and when distilling her impressions of those visits, comments on the high frequency and intensity of resident-to-resident violence and conflict at the house, did management reach the same conclusion about the Melbourne House as Ms. Barbuto did?
When I look through all of the material that I have, I can see extraordinarily strong efforts and competence from our staff around supporting all of the individuals with their behaviours of concern, and language you want to use. Extremely strong competence on that, around how they both manage to support people to be well and happy and achieve their goals, and when things were escalating, to redirect that to de-escalate the situation, or certainly not to let it escalate further.
I wonder if you'd mind directing your attention to the question Mr. Griffin asked. Let me repeat it. When Ms. Barbuto, in paragraph 26 of her statement, describes how she's been a visitor at the Melbourne House for a long period of time, and when distilling her impressions of these visits, comments on the high frequency and intensity of resident-to-resident violence and conflict at the house, did management reach the same conclusion about the Melbourne House as Ms. Barbuto did? That was the question asked. What is your answer to that question?
I think my answer to that question would be similar when this was asked previously, around that I said again already that any violence is noted where there's harm, which you have examples, is high, and the complexity of the clients. I think my answer remains the same.
Well, you're familiar with the provisions of the Disability Act in Victoria, which I raised with the community visitors, I take it. Firstly, section 30 of that Act, which sets out 8 matters they can inquire into.
Yes.
And then section 130 sets out 5 entitlements of a community visitor when visiting a service provider, including, and I quote, inspect any document relating to any resident which is not a medical record, and any records required to be kept under the Act.
Yes.
Life Without Barriers, I take it, doesn't dispute that that is a clear legal entitlement that resides in the community visitors.
Absolutely. I do not dispute that.
And Life Without Barriers would always attempt to comply with the law in the jurisdiction they were working in, wouldn't they?
Yes.
But you've no doubt heard evidence in this inquiry that community visitors had enormous difficulty in accessing records, particularly in relation to incidents. Do you accept that?
I do. I read the statements and heard the oral evidence as well.
Have you made inquiries over your period of 10 years as a CEO as to why in the Melbourne House, and according to the visits of the House as well, but in the Melbourne House, why staff were unable to satisfy the visitors by letting them inspect the relevant documents they're entitled to see?
In regards to what I've personally done around that, so my understanding firstly is that that has been resolved, that matter, that concern, sorry, with the Dr. Pearce's office now, in regards to the method by which we will provide the community visitors to the Melbourne houses access to the critical incident reports and other information that they may want.
Just pausing there, can you describe to the commissioners what that resolution is as of 2021?
So my understanding is that we have agreed that there will be print-offs of the system of the critical incident reports in the houses when the community visitors go to visit. And because those visits are unannounced, if they occur and perhaps a report isn't in there, then there's a responsibility to make sure that file's fulsome, when the visitor occurs. Because they're unannounced, so it's sometimes difficult, obviously, to know when they're coming.
When did you, Life Without Barriers, cease to be the operator of the Melbourne House?
I think October, November 2020.
Mm-hmm. The evidence suggests, Ms. Robbs, that up until mid-2019, the lack of access to the documents I've referred to was a source of considerable frustration to the community visitors. Do you dispute that assertion?
No.
And so any resolution has occurred in your mind sometime after the middle of 2019?
Sorry, I was working back from the fact that I personally have assured myself that it's resolved after reading the information and hearing the witness statements. Sorry, before that, I know that the community visitor met with our team as they outlined in their statement in 2019. And I understand that from that point to very recently, we have been trying to work with them so that we can give them suitable access in a way that met their needs.
This series of questions, Ms. Robbs, began with Mr. Griffin asking you, have you made inquiries over your period of 10 years as CEO as to why in the Melbourne House staff were unable to satisfy the visitors by letting them inspect the relevant documents they are entitled to see? In a series of answers, you have said the matter has been resolved because some new arrangements were put into place. But have you, as Mr. Griffin asked, made inquiries about why it was that staff could not satisfy the community visitors by letting them inspect the relevant documents?
Thank you, Chair. This came to my attention in 2019 when the meeting was held between the community visitor and our senior team. And at that point, yes, there were discussions around why it was difficult to be able to make sure the community visitors had the information that they sought.
How could it have taken so long for this issue to come to your attention. What were your managers doing?
The concerns from the community visitors from up to the meeting on the 2019 with our senior team, the concerns had not been escalated outside of the individual community visitors and our individual managers. And at the time, the reports for community visitors were held at a local level and not centralised.
So coming back to my question, why did it take so long for this to be brought to your attention? What were your managers doing?
I think my managers at a local level were trying to respond and solve the issue.
With respect, Ms. Robbs, 8 years of complaints from community visitors, highly skilled and professional volunteers doing a specific role. It's just not acceptable, is it, to suggest that such a simple issue would take 8 years to come to a point where there was, to use my words, a serious discussion or consideration on your part about what to do.
So two things I might say to that. I agree with you that it's been an extraordinary amount of time to resolve that issue that actually ought to have been very easily resolved, because community visitors all across this country access our services every day and access the critical incident reports in lots of different jurisdictions. So there's no reason why that wasn't possible. I agree with you on that.
Well, have you made inquiries as to why, in the Melbourne House at least, the community visitors had such little success in accessing those documents?
So my understanding, and I think this did come out in the community visitor panel, was that it was around certainly from 2017, we wanted the community visitors to access the records online on our system after we brought eyesight in, and they preferred the hard copy, and that seems to have been a point of frustration from both sides. I would say that two things, if I can comment, improvements that have been made to address that, which I agree, far too long for something that should have been easily resolved. The first is that we now, all community visitor reports are logged centrally with our National Safeguarding Unit and reviewed so that we get the information directly. And the second thing is a really good improvement from Dr. Pearce's office, is that she now sends an annual letter to providers, and I received one earlier this year, with a summary of the concerns and findings from the community visitors, and that then gives me an opportunity to respond, which is really helpful.
Look, I appreciate the evidence, Ms. Roberts, but it's really not addressing the issue that I'm raising with you.
I'm trying.
The only explanation you offered that was in 2017, the community visitors wanted to see a paper copy and you could only offer an electronic copy. What I'm saying to you is that the community visitors had a legal right, indeed an obligation, to look at this sort of material. And your organisation frustrated them over and over again. It was raised with management on many occasions because the community visitors would write a report after their visit, and they'd say in the report, we couldn't access it. You can't shift the blame onto the OPA or the community visitors. This is totally within LWB, and I'm trying to understand why LWB management didn't immediately address the issue.
So the records that I see are around local management trying to, from 2017, after we had the system, before that different, trying to negotiate access for the community visitors to the system, trying to encourage the community visitors to use the system.
Let's talk about before 2017.
Right.
We're all on paper, weren't we?
Yes.
And so when an incident occurred,
Yep.
the worker would get their pen and quill and they would write it up. That document would be kept, a copy would be kept in the home and sent to whoever it needed to be sent to.
Yep.
When the community visitors attended, they went looking for the initial incident report and what response had been made to that by LWB management.
Yep.
And frequently they were denied access. So how does that explain between 2011 and 2017 what I would describe as a contemptuous disregard for letting them do their job?
So when I read the material, our staff were trying really hard to make sure that those incident reports were in a folder in a suitable format. I appreciate that that didn't meet the community visitors' needs, and I appreciate that they gave us that feedback at a local level because they leave the reports in the house, so they certainly let us know at a local level that they were not happy with their access. And I don't have a reason, as I sit here today. I do understand after the system came in, I appreciate that. I don't, to a point, I don't know why we weren't able to, between 2011 and 2017, have a more reliable approach to providing that data. But I am absolutely confident from looking at the material I've seen that it was not the intention of the staff to deny any access at all.
You said more than that. You said that the staff was actually actively attempting to satisfy the requests or the requirements from the official visitors in relation to documents. That's what you say.
Yeah.
Your review of the document shows.
Mm-hmm.
What I'm going to ask you to do, Ms. Robbs, is to identify the documents, not now, you can take this on notice, identify the documents that you say you are relying upon in order to conclude that the staff were doing their best to satisfy the requirements of the official visitors between 2011 and 2017.
I can certainly do that.
Thank you.
Mr. Robbs, can I move to the meeting between the OPA and Life Without Barriers on the 24th of May 2019?
Mm-hmm.
And can I indicate that that appears in the documents at OPA.9999.0004.0378 and appears in Hearing Bundle B at tab 122. That was a meeting which was convened by the public advocate. And you understood, did you not, that it was convened by the public advocate because of her frustration with certain issues with LWB?
Yes.
And present at that meeting was David Benno, BNAU, the ALG State Director, Ashley Crichton, the National Client Services Manager for LWB,
Mm-hmm.
Peter Singh, the Regional Manager, Disability and Aged.
Mm-hmm.
Is Peter Singh also LWB?
Yes.
Dr. Pearce, the Public Advocate, and various other people, including Chris Barbutu and Leonie Swift.
Yep.
That was obviously a serious meeting because, am I correct in understanding that Ashley Crichton, your National Client Services Manager, flew to Victoria?
No, he lives in Victoria.
He lived in Victoria. Anyway, it was so important that he attended that meeting.
Yeah, that would be the kind of meeting his role would have him attend.
After that, did you know he was attending that meeting before he attended it?
I'm not sure. Ashley didn't report to me at the time, so I'm not sure. Sorry.
Subsequent to that meeting, did anyone report to you as to the result of the meeting?
I certainly was aware that the meeting had been called because, as you say, Dr. Pearce is a really important regulator, really, for us. So I was aware the meeting was called, and I expect I would have had a verbal summary after the meeting.
Do you have any recollection of what you were told about the meeting?
Not in specific detail, other than that concerns had been expressed and frustrated, as we have covered. Yeah.
Did this meeting give you an indication that LWB's so-called proactive strategies were insufficient?
When you refer to proactive strategies, what do you mean
You
by
referred
that?
to a number of things that LWB was doing in a proactive nature. But let me perhaps deal with it this way. In the minutes of that meeting, in the document I've referred to, and it's on the screen, I believe, is that right? You'll see point 2, incident reports. Chris, which is Chris Barbutu, the community visitor, said community visitors have been unable to view reports over 18 months since LWB moved to eyesight. We're given an undertaking as community visitors would be able to view them. One summary report has been supplied, but the report only had resident names and one line about the incident. Nothing re any action taken. Preference is to have incidents sorted by facility and residents. Ashley said he can change fields to include the name of the residents and actions. You understood that was discussed, didn't you?
Perhaps not at that granular level of detail, but the topic, yes.
As a result of that meeting, are you aware whether or not Ashley did anything in particular?
I thought there may have been, I can't accurately see the document. I thought there may have been action items committed to out of this meeting, or perhaps that may have been an internal action document prepared. And I understand that there were commitments made to address the concerns, like the one there about Ashley.
Then point 3, lack of responses to CV reports and CV reports not at residences. Also an ongoing problem.
It might help if we could have the relevant,
Sorry, I'm sorry.
sometimes I highlight the relevant part to perhaps help. Is that possible? Thank you.
So I'm now reading at point 3. Does that assist?
Yeah.
Thank you.
Yeah. Lack of responses to CV reports and CV reports not at residences, also an ongoing problem. Victorian protocol requires providers to respond within 21 days. Written responses to be kept at the house, so if CVs change from visit to visit, the CV can view the last report at the house. That's all a reasonable expectation on the part of the community visitors, isn't it?
Yeah, absolutely.
And indeed, without that expectation being met, that would inhibit their ability to do their job.
I would think so.
Do you know one way or another whether the action proposed there, OPA to send the reports on outstanding responses and open issues to Ashley, Peter and David occurred?
Not that particular action, sorry. We would have focused more on the provision of our incident report. Sorry, I'm not across that one.
But you certainly accept that a crucial part of the process was that when a community visitor wrote a report, the provider was required to respond within 21 days to any relevant matters raised.
I do understand that.
And you do accept, don't you, that that frequently wasn't complied with?
Which is definitely one of the contributing reasons to us centralising that, to get some more control and assurance over that now.
There's also an agenda item at point 4, investigations into resident bruising. Are you aware that the visitors had expressed concern that the bruising to residents wasn't adequately documented?
I don't think before this hearing that had been called out in the same level as the non-provision of the reports.
Yes.
Yeah.
And you can see there the CVs were apparently concerned. Staff were only marking a bruise chart with an X, not details of the size of the bruise. CVs saw bruising on the front and back of legs that was not consistent with the explanation that a resident had fallen.
Sorry, I don't have it in front of me, but I'm sure
I'm sorry.
that's accurate.
Just show the witness, point 4. In point 4, which I just read from,
Mhm.
that's a very serious concern, isn't it?
I think if the concern being expressed is about whether we're accurately documenting that, then I think that would be a concern.
Well, it's firstly how accurate the document is, and secondly
Yeah.
is whether the observation of the resident seems consistent with the explanation about how they sustained the bruises. At the very least, that requires a response from LWB, doesn't it?
So I'm not clear if they're asking for a response or, and I can see that the action item is training. So I'm not clear if they were asking for a response in the meeting or they were asking for us to do something else.
What I
Sorry.
suggest to you is that if a community visitor in a report observed that the explanation for the bruising didn't appear to be consistent with what they observed, that would be a matter which you would respond to, presumably, wouldn't you?
That would be a matter we'd want to look into,
Yeah.
yes.
Because it goes to the integrity of the record, doesn't it? Is the record accurate?
Yeah, I think also if the community visitor, if we're assuming from this that community visitor would put something like that on their report to us, then I think that, as was clear before, we've got an obligation to look into all of those matters and report back within the 21 days.
As a result of the meeting on the 24th of May 2019, have all your staff in Victoria been trained as to their obligations under the Disability Act in respect to community visitors?
I don't think we'll have a particular module on that, but I would, with some confidence, say that our training for staff includes the relevant regulation for that state. So I would think that staff would be clear. And certainly my review of the material from the staff at the time didn't indicate that they were unclear about that responsibility.
So a failure to comply was deliberate
No,
because they were clear.
no, it wasn't. I don't feel it was deliberate at all.
What basis do you say it wasn't deliberate? Clear obligation, systemic non-compliance. Why shouldn't this commission draw a conclusion that that was deliberate on the part of LWB staff or management?
So which part was deliberate?
Sorry?
Which part, what was the deliberate
The failure to
action?
give access to the documents that they were entitled to see on a consistent and systematic basis over a number of years. Why shouldn't the commissioners draw a conclusion that in all the circumstances that was deliberate?
I would suggest that when I review the emails between our staff and I look at the documentation, I think it's very clear that it was not deliberate and that they were clear on the requirements and they were trying, albeit they may not have met that requirement. I appreciate that. But it's very clear to me that various people were trying hard to do that and understood the importance of it. Notwithstanding, I appreciate it may not have happened to the community visitor's satisfaction.
Chair, can I ask if any commissioners have questions on the section involving community visitors?
Yes, Commissioner Galbally, do you have any questions on the community visitors?
No questions, thank you.
Commissioner McHugh.
No, thank you.
No, I don't have any questions either, so please continue.
Ms. Robbs, can I ask you what your experience has been since the NDIA QSC has come into operation in terms of reporting matters to them, particularly in the context of Victoria, how it might have differed from reporting to the department or someone else?
Well, I think one of the things that may have varied is the Quality and Safeguarding Commission has implemented a consistent national approach to the classification of incidents and the approach and the way that they're managed across the country. Because we are in multiple jurisdictions, we can see that we've had to do the work, so we can see that that has been slightly different in some jurisdictions than others. I can't talk to the specifics, sorry, for Victoria, but it would be moving from state-based systems to one federal consistent system would probably be the main difference. The community visitor program obviously still runs in Victoria, yeah.
Has that made it easier for Life Without Barriers, the ability to take a national approach through those national bodies as opposed to dealing with state by state?
And with regards to the regulation?
And reporting.
I think it enables us to better do the work that I spoke to earlier, which is compare jurisdictions for reporting rates and such like, because the definitions are the same. But that being said, for Life Without Barriers, we already had to harmonise that, for better language, when we brought eyesight in nationally in 2017. So we really had already done that work as a national organisation anyway, so it didn't make as much difference to us. I can't really comment on what it would have done for organisations that were just working in one jurisdiction.
And within Life Without Barriers, do you have an internal investigation unit now?
Yes, we do, yes.
Can you tell the commissioners how that unit is set up and what its role is?
So that unit is set up particularly to investigate matters of concern. So, and there's a definition around the matters that they investigate. They look at matters that relate to staff conduct, predominantly. That's where their history came from, really from investigating matters of concern as they related to staff and clients, particularly children at the time. That's the roots, I guess, of the unit. The unit currently sits, it's staffed by people who have investigation skills. So there are ex-police officers, child protection workers, other sort of senior practice social work qualifications in that unit. We were particularly looking for people who have experience at investigating, obviously, matters and making findings. That unit now reports through to the Office of the Special Counsel, and they report directly to me.
And generally, those matters are outlined in your statement as to the current arrangements you have. You mentioned the unit investigating the conduct of staff.
Yes.
Do they have a remit to investigate allegations of resident violence?
Sorry.
Perhaps
I
we'll
do know
take,
this answer, sorry.
perhaps we'll take that question on notice
Yeah,
as well.
please. Sorry, yes.
Because I'm interested in how Life Without Barriers is currently addressing the issue of resident-to-resident violence.
Yep.
Would you care to elaborate on your current approach to that issue?
Yeah. So notwithstanding, I'll come back on that answer. The way that we would the team that we would work on the client-to-client, resident-to-resident violence is really through our practice and our behaviour, positive behaviour support team. So we have a lead practitioner for positive behaviour support that reports to our executive responsible for disability. And we have a lead practitioner in our disability services. And together they they are responsible for the teams that conduct that work across the organisation, and or the external practitioners that people choose to support them with their positive behaviour support plans through the scheme. And they are responsible for supporting us to make sure that within those plans, one, people have good plans and that our staff are trained on them, and that we're doing everything that we can to reduce the client-on-client incidents. That would be led through our practice and positive behaviour support streams.
Are you able in 2021 to do a comparison between houses as to the level of resident-to-resident violence? And if so, how do you do that?
So we are able to extract data from the eyesight system around the incidents that would be classified in that category, and then use that to advise, I guess, us and the operational leaders, particularly the people responsible, as I've just spoken, for the positive behaviour support and staff training and support around how we might need to improve.
For how long have you been extracting that data?
Well, I see in the material that around the Melbourne House, just as an example, that there's some material in there that was provided to leaders, I think maybe 2018-19, because I don't think it would have been easy to do before eyesight. Yeah.
Let's assume that your leaders got information concerning the Melbourne House in 2018.
Mm-hmm.
Have you got any information that enables us to compare whether violence was increasing, decreasing, remaining the same?
For the Melbourne House?
Yes, I appreciate you're only in control of the Melbourne House for a short period after that, but...
It may be already in the... Sorry, I know there's information in here around that. I'm not sure if it particularly relates to the Melbourne House, but it may well be.
What about more generally? If you've been extracting information of this nature since 2018,
yeah,
presumably in respect to all of your houses,
yes.
what have you learnt, if anything, between 2018 and 2021 as to whether what you're doing is decreasing the level of violence?
So we discuss, we've had several discussions, and I'm happy to provide if it's helpful, at the practice committee level as well, around the resident-to-resident incidents, what we are doing about it, what's in our plan to try to do more and better, particular areas of concern or development.
Give me examples of positive things you've done in the last 3 years to try and address that issue.
Of the client-to-client? Yep.
Is it more staff? Is it more resources? Is it better training? Exactly what in tangible terms have you done? And then tell me whether you think it's had an effect.
So a couple of things that we've done that we think has had a positive effect. We haven't done anything we think has a negative effect. So a positive effect, firstly, would be that we used to have all of the psychologists and clinicians that were performing the behaviour support function. They used to report locally, and we thought that was the best thing to do because they were part of the care team locally. What we then decided to do was to report that nationally and bring that together as one team across the country to get an uplift in the quality of their practice. And we're very confident that that's been achieved. That also enabled us to recruit some more expertise at a national level. So we were able to secure some the best expertise in the country, which has definitely also helped us improve that practice. We also have implemented new, perhaps training for staff, particularly in response to, I think Ms. Taylor spoke to the work with us in December 2020 around restricted practices. So we introduced some new training, particularly targeted at that, which we know because there's a competency check at the end of that training. And so we know that based on the competency check, people were more competent and confident after the training than before.
And do you extract this information in respect to every house you operate, or only in relation to houses where you've been notified of an issue?
No, sorry, the training I commented on was around an issue. Well, the information is in the system. So I'm not a technical expert on the system, but I would imagine it can be extracted in lots of different ways.
And who is responsible in your organisation to analyse that information, and to whom do they report the results of their analysis?
So if it's around the board level that I've discussed, then as I said before, that those reports are pulled together by the quality and risk portfolio, and the executive responsible for quality and risk reports directly to me. If they are around teams wanting to improve their practice, wanting to look at their own data, etc., then that would happen within the service delivery teams.
Do you have the capacity to compare data generated by LWB with similar data generated by other major providers?
I don't think we do, but the Quality Safeguarding Commission certainly would have that from the point where they, have taken responsibility, certainly.
And have you had any discussions with the QSC as to whether they can tell you how you're doing compared to other providers?
I think as Ms. Taylor outlined in her statement, the QSC has had a particular focus on restricted practices. So they've been able to share with us how we're performing or travelling on that. They don't share information that's inappropriate about other providers, but they certainly can bring that context to our data.
On a more positive note, Ms. Robbs, I want to give you the opportunity to address the commissioners as to whether, based on your experience, as to improvements that you might see, recommendations that you might wish them to consider based upon the experience of Life Without Barriers and your 10 years as Chief Executive Officer, in the broad context of what we've been discussing today. It's your big opportunity.
Right.
Purely voluntary.
Full of surprise.
Indeed. That is a big question, but I can't not take some sense of opportunity there. I think Commissioner Galbali's question earlier would be the piece that I would go to probably around the positive impact that can be had in people's lives when they have more choice and control about who they live and where they live, who they live with and where they live, and the possibilities and potential for that through the NDIS and everything that comes with that. But that's not going to just happen. That has to be a real focus and intent. Otherwise, it could just become in the design, but not in the implementation. So for me, if I had to think of a recommendation in general terms, there would be something there about continuing and indeed ideally escalating the point that Commissioner Gabali was making and the point that Mr. McNaughton made around more contemporary models of care, particularly for people with more complex needs.
Chair, can I hand back to you as to whether any commissioners have any questions in the last tranche?
Thank you. I'll ask Commissioner Galbally first. Do you have any questions for Ms. Robb?
And just to follow on in some ways from where you left off, and the issue of these houses being about care, and then somebody raised the fact that they're about support. There's two questions. Number one, are they about development of people? And number two, are they about a home that you live in rather than, care places or support places? So just trying to understand whether they're beyond a sort of welfare model that was, Yeah,
no, thank you for the question. I'm not sure if you saw me slightly flinch at the word care when it was mentioned earlier. Of course, we want to care in the homes for people. Of course, we want people around them to care for them. In fact, we know that the evidence says that what actually keeps people safe are relationships with those people around them, that they care about them and that they're connected to community. The evidence tells us that. So we do want people to care. The reason that I perhaps responded to the word care is because sometimes in the way we use it, it has a paternalistic tone to it, and it indicates meeting people's basic needs. And that's not what we want or what is happening in lots of the homes. It is absolutely about building people's community, genuine community inclusion, not just being present in the community, but being included in the community and building their skills and their development and enabling them to live the life they want to live. And, I think there was some good stories shared there about how Sophie particularly had developed her independent skills, which is a fantastic thing in her time. So that's why I think it is important that we're careful with the use of the word care, because I think it doesn't properly define the role of the worker, the role of the provider, or the experience, most importantly, that we want people who live in these homes to experience. So whether it's development or support or something, another term that someone comes up with, I think there has to be something better than care. And the second point to your point around a home, as I travel around, as council asked me, I see lots of fantastic examples where these homes really are people's homes. They've often lived there for a long time. Their bedrooms are really personalised. The homes are really personalised. They're safe. They enjoy living there. Lots of examples of that. But the reality is also that it's balancing that with the fact that paid staff are in the home and a community visitor can show up unannounced and paperwork's got to be kept because we're properly accountable. And all of that accountability is really suitable and necessary, but it's balancing that up with making it a home environment. And that's something that we talk about all the time and can get much better on, I think. And I think there's a link for both of those things to my comments before about the, as I was given the opportunity by council to speak about us thinking more broadly about not only the bricks and mortar, but the models that support people to really realise their potential.
Thank you. Commissioner.
Thank you. My topic is, or my final question and topic is about supported decision making, and it sort of relates to what Commissioner Garabally was asking. Is we heard last week that there were different views about how Sophie might explore and implement her desire to have an intimate relationship. Workers and parents and herself have different views. So describe perhaps briefly, how does Life Without Barriers focus on the person to really give them that support to be able to do that in a way that they want, and recognising dignity of risk, which we've talked about?
Yes, thank you. I think the first thing I'd say to that is that, back to my comment, that the thing that really helps people most are the relationships with the people around them and closest to them. And that is first and foremost the families. We absolutely understand that. And then for lots of people, the staff in their life are really important relationships for them as well. So equipping those staff, empowering those staff, enabling those staff closest to people to know that their job is actually more than care. Of course, they've got to meet the care needs, but it's more than that. It's really helping the person on their journey in life. That's one of the first things that, for someone like Sophie, and I can see evidence that she did have that from some really outstanding workers. That's the first thing we can do. And then the second thing, which we do, but I think more could be done for us and the sector, is around where people perhaps do not have strong decision maker supporters or strong family members or advocates in their life. It would be really helpful for everyone to have someone that helps them realise what choices are available to them.
Thank you. Thank you, Chair.
Ms. Robbs, a couple of questions relating to Life Without Barriers financial reports. The financial statement for the year ended 30 June 2021 contains certain information relating to compensation for key management personnel. Who are the key management personnel?
My understanding is that is made up of a definition through our auditor, so come through the financial reporting standards about who's in that grouping.
Yeah, no, I'm wanting to know how many there are.
Oh, sorry.
Within Life Without Barriers.
I think that has got certainly.
Presumably includes you, so it's at least one.
Certainly includes me, and I think I would think there's, I don't know, maybe
if you don't
100.
know,
I don't know. Sorry, I'll need to take that. My apologies.
You don't know.
Sorry. Yes, I can take that.
All right. My second question is: how long has Osborne Law been solicitors for Life Without Barriers in relation to property matters?
Number of years. I don't know the particular year, but it is in all of the annual reports.
I assume that none of the directors of Life Without Barriers receive any payment for their services as directors. Is that correct?
No, that's not correct. We do pay our directors.
You do pay directors?
Yes.
The amounts are not revealed in the financial statement.
I'm happy to share that information if that's helpful.
And the two directors who serve on the board of JobFind LWB Proprietary Limited, do they receive additional remuneration because of their role as directors of that company?
Well, one of those directors is me, and I don't receive additional remuneration for that because I'm a paid employee. And the other director will receive some remuneration for that entity, not from Life Without Barriers, though, from the Job Life entity.
That's a joint venture between Life Without Barriers and a separate company known as Angus Knight Proprietary Limited.
Correct.
Yes. And the same question in relation to LWB Disability Services South Limited. Are there directors of LWB on the board of that company?
There is one director of LWB on the board of that company, and yes, they will receive some small level of remuneration, I would sense, to be on that board. Again, happy to provide the information.
All right, thank you. You appreciate that part of our job is to make findings about
Yes.
matters that have been explored in evidence. And as part of that, it's necessary, or may be necessary, for us to form views about the evidence that has been given.
Yes.
One possible view of the evidence you've given, and I say possible view, is that you are very reluctant to accept that there has been any significant deficiency in the operations or services provided, operations of or services provided by LWB to people with disability, unless the evidence appears to you to be irrefutable and undeniable. I'd like to give you an opportunity to comment on that possible view of your evidence.
I would hope that in my preparation of the witness statement and in the way I've tried very hard today to answer the questions in the best of my knowledge and bring my experience to those discussions, and in my open apology particularly to the people with disability and their families that have been part of this, I would have hoped that the Commission would be clear that I have taken all endeavours to be as helpful and answer the questions as best I can.
Thank you. The second question, and it's a related question, is that a possible view of your evidence is that as the Chief Executive Officer, you tend not to take a proactive approach in detecting and rectifying deficiencies in the operations of Life Without Barriers, but rather your tendency is to respond to revelations about deficiencies as those revelations occur. That's a possible view. I'd like you to give you the opportunity to comment on that as well.
So, with a lot of strength, I would not agree with that possible statement. I know how hard I work and how we work at Life Without Barriers to be extremely proactive.
The question isn't directed to how hard you work, it's directed to another issue.
To
the issue of whether you tend, as the Chief Executive Officer, not to act proactively detect and rectify deficiencies, but rather to respond to revelations about deficiencies as and when those revelations occur. That, I suggest, may be a possible view of your evidence.
Thank you. I think I and Life Without Barriers are extremely proactive around trying to identify where we need to improve, very open with ourselves about the things that we need to do better, and then proactive in trying to make those changes so that, most importantly, the experiences of the people we're supporting and our direct frontline staff are better. I feel it's a real strength of the organisation that we do that extremely proactively and with ever vigilance to the need to do that.
Thank you. I'll ask Ms. Mitchell-Moore if she has any questions to ask of you. Do we have Ms. Mitchell-Moore online?
Yes, I'm sorry, I'm struggling with my mute button, Chair. I apologise.
That's why you became a lawyer, Ms. Mitchell-Moore. Technicalities are another issue.
Indeed, yes. Chair, I have no questions for Ms. Robbs. Thank you.
Thank you very much. I'll assume that no other legal representative has any questions of Ms. Robbs unless someone metaphorically leaps up. In the absence of that occurring, thank you very much, Ms. Robbs. That concludes your evidence. Thank you for coming to the Royal Commission to give evidence. Thank you for your very detailed statement. So we appreciate your attendance. Thank you.
Thank you.
Yes.
Chair, that concludes the oral evidence I intend to adduce in this public hearing. I have some draft closing directions for your consideration. I wonder whether we might adjourn for a period of 10 minutes or so.
Yes.
To enable you to consider those and any closing you may wish to make.
Yes. Well, what I might do, let's do that, and we'll come back in 10 minutes or so. All right, we'll adjourn, and it's now nearly 20 to 4. We'll adjourn until 10 to 4.
The Royal Commission is adjourned.
Yes.
The Royal Commission is resumed.
Yes. I've been provided with directions. What I propose to do, draft directions, what I propose to do is to read the directions with which I have been provided. If at the end of my reading of the proposed directions, any legal representative wishes to make any comment or make any submission about the directions, then there will be an opportunity then to do so. Otherwise, I shall make the directions as in the document. The proposed directions are as follows. 1, any witness who took questions on notice during this hearing should provide his or her answers in writing to the Office of the Solicitor assisting the Royal Commission by 12 January 2022. The answers should be targeted and concise and not address additional or unnecessary matters. Counsel assisting the Royal Commission may tender those responses into evidence. 2, by 28 January 2022, Counsel assisting the Royal Commission will provide a list of all documents he wishes to tender into evidence, including responses to questions on notice, on a confidential basis, to the parties with leave to appear at this hearing. 3, parties with leave to appear should advise the Office of the Solicitor assisting by 11 February 2022 if they wish to suggest any additional documents for tendering by counsel assisting. At the same time, they should identify any parts of the documents to be tendered that they consider need to be removed before the documents are made public, with reasons. 4, counsel assisting will tender those documents into evidence which he considers appropriate and will do so in chambers by 18 February 2022. 5, counsel assisting the Royal Commission will prepare written submissions following the hearing. By 18 March 2022, these submissions will be provided on a confidential basis to parties with leave to appear, to any organisation that received a procedural fairness letter from the Office of the Solicitor assisting the Royal Commission in preparation for this hearing, and to all states and territories. 6, any responses to counsel assisting's submissions should be sent to the Office of the Solicitor assisting by 1 April 2022. Those responses should be concise and should not include any additional evidence. 7, after receiving all written submissions, there will be a short hearing for oral submissions, which will be scheduled in due course on a date to be determined. Does any legal representative wish to say anything about those draft directions? Thank you. If not, then I make the directions that I have just read out. So they are the directions of the Commission for the purposes of this hearing. Before adjourning the hearing, I would like to express the thanks of the commissioners to everybody who has given evidence. Particularly, we would like to thank Sophie, who gave evidence, as you will recall, on the first day. Sophie, if you are watching or will watch, we are very grateful to you for being prepared to tell your story to the Royal Commission. It has not only been your story, but it has raised issues of profound importance to many people with disability, and we are sure that they will be grateful to you as well. We express our appreciation also, of course, to Michelle and Greg and to Paul, Catherine, and Jennifer. I repeat that we are grateful for the evidence given by other witnesses, including the very detailed statements that we have received and the thoughtful contributions that have been made by a number of the witnesses on significant policy issues. I want also, on behalf of the commissioners, to express our appreciation to Council assisting the Royal Commission for the work that they have done in preparing for and presenting this hearing. The Office of Solicitor assisting, led by Lorna Davidson and Anik Wayne, the counselling team, which as always has done an extraordinary job in making sure that witnesses who require support receive that support and that the hearing is conducted in a trauma-informed way. The hearings and logistics team that has an important role to play in the organisation of the hearing, and of course our Auslan translators, Law in Order, and all who have otherwise contributed to a hearing. As I have said in many of the hearings that we have held, these hearings take an enormous amount of preparation and organisation, and we have held 20 hearings in the course of the Royal Commission. Each of them has been a major undertaking, and the conduct of the hearings reflect great credit on everybody who has been associated with the preparation of evidence, the organisation of the hearings, and the presentation of material at the hearing itself. So thank you again, and we will now adjourn.
The Royal Commission is adjourned.